From item number 5 to 15.
Yeah, please, your lordship. On the consent of the order, sir, I beg to mention item number 11, lordship.
Yes, what happened, gentlemen?
Lordship,
What happened?
lordship, my senior had some personal difficulty, lordship. His grandfather was.
Okay, counsel for the appellant, please for time. The counsel representing the respondent does not object. Hence, list after summation.
May I please, your lordship? I'm the appellant in item number 10 in the daily list. With the consent of the other side,
Mhm.
and we are finally adjourn the matter for today.
And counsel for the appellant submits that he is not in a position to argue the matter today. His consent has already been sought from the other side. The writ appeal is of 2020, gentlemen.
Yes,
Pending for admission.
yes,
What is the issue involved? Just give us a brief outline.
yes. Actually, I'm very new to this matter.
Okay, very well. List of
Alright,
summation. Okay, okay, very well.
Item number 14 to 22.
May I please, lordship? With the consent of other side, I beg to mention item number 15, lordship.
15,
15, lordship.
and counsel for the appellant has circulated an adjournment slip. The other side has no objection. List of summation.
Obliged.
Number 31 to.
Daily list for orders, item number 1 to 3.
What has happened, AG sir?
This is the appeal, lordship.
Yes, sir, we recollect.
Basically, lordship, the state has filed the appeal because the procedure laid down under the act regarding resignation and withdrawal of resignation, lordship, that
Contempt.
was not properly followed, and therefore he is not entitled to resume his office. That is our case. Two aspects, lordship. He had sent a resignation later on 18th September, and subsequently.
Will you please read the findings of the learned single judge?
Yes, Lord.
Then we will appreciate your argument.
Lordship.
The reasons assigned
Lordship.
at para number.
That's meant to put those. Move held to. Impugned judgment is at lordship, page 135.
Yes. Read which para you want to refer.
Yes, I would like to place the findings. Paragraph 19, 15 to onwards, lordship.
You let us know where
That's
from
for-
we should start. Where from should we start?
Page 148,
Para.
15.2.
Yes, very well.
Thus, the above interpretation of section 9 of the 1989 Act leads to the conclusion that the first day of the period is required to be excluded from consideration of the computation of the time period mentioned in section 72(1) of the Panchayat Act. Admittedly, the letter of resignation was submitted by the petitioner on 18/9/2021, and as such, 18/9/2021 is to be excluded from consideration while computing the 15 days period. Viewed in this context, the last day of 15-day period for withdrawal of the letter of resignation was 3/10/2021. It is not in dispute that the day 3/10/2021 was Sunday, and therefore the last date for petitioners to send a letter of withdrawal of resignation would have to be held from 4th October 2021, Monday. The prescription contained in section 72(1) of the Panchayat Act has made it clear that the office of the president of Jilla Parishad shall become vacant on the expiry of 15 days from the date of such resignation, unless within the said period of 15 days, the incumbent of the office of president withdraws such resignation by writing and sending. Lordship will kindly mark this. The Honorable Single Judge also has noted the same thing,
Yes,
the
yes,
language
yes.
of the Act. By writing and sending it to the government. By taking note of the provisions contained in section 5 of the 1915 Act, if the period of 15 days is to be computed from the date of resignation submitted by the petitioner in writing, that is 18/9/2021, then in order to compute the
The
15 days-
issue,
It
what
was not
we
on
can-
those 15 days.
no, the issue is whether the first day and the last day, first day can be excluded. That is the issue.
No, that is not the issue.
Then-
The issue is not regarding fee. What he has done, he has not submitted the resignation to the appropriate authority.
Mhm.
According to that, the submission of resignation is one aspect and withdrawal of resignation is another aspect. Withdrawal of resignation must be addressed to the government.
Right.
He has to write and send it to government.
Mhm.
That means what is government? The principal secretary of this particular department.
Okay.
He wrote it to the deputy commissioner.
Mhm.
So that is where there is a default on the part of the
Mhm.
person concerned
Okay.
regarding his withdrawal.
Mhm.
So that was the area where Lordship was pleased to put me that whether I have some case laws or not.
Oh,
I
right.
have some case laws on that
Let's,
point,
let's,
Lordship.
let's see.
May I
Uh,
proceed because that
Yes,
will-
yes, please carry on.
Yes.
Yes.
By taking note of the provision contained in section 9 of the 1915 Act, that is the General Clauses Act, if the period of 15 days is computed from the date of resignation submitted by the petitioner in writing, that is 18/9/2021, then in order to compute the period of 15 days, the first day, 18/9/29 is to be excluded. And if after excluding the first day, 18/9/2021, the period of 15 days is computed, then the 15 day falls on third. If the last day of the prescribed time period is 3/10/2021, in the case in hand, which was a closed day for the office being a Sunday, then by virtue of section 10 of the 1915 Act, the 15 day had to be taken as 4th October 2021.
Mm.
As already indicated above in paragraph 13, if a president of Jilla Parishad who has earlier submitted a letter of resignation wants to withdraw his such letter of resignation, then he has to send such letter of withdrawal of resignation to the government.
Mm.
This is where also the learned single judge said that it is to be government.
Mm.
One distinguishing aspect between the act of resignation and the act of withdrawal of resignation is that in respect of the former act, the letter of resignation has to be sent to the government through the jurisdictional deputy commissioner.
Mm.
But in the case of letter, which there is no such requirement of sending it, the letter of withdrawal of resignation through the jurisdictional deputy commissioner. The president can directly send the letter to the resignation up to the government. The president can directly send the letter of resignation to the government. The word send, as per the Oxford Dictionary, means cause to go or to be taken to a particular destination, arranged for delivery of, especially by post. The provision of section 72(1) of the Assam Panchayat Act is silent about any requirement of receiving the letter of withdrawal of resignation, either by the jurisdictional deputy commissioner or by the government. If the incumbent in the office of president of a Jilla Parishad who has earlier submitted a resignation performs the act of sending the letter of withdrawal of resignation to the government within the period of 15 days from the date of his earlier letter of resignation, then the act of resignation is not supposed to take effect. And in such case, the incumbent of the office of the president of Jilla Parishad shall not be deemed to have been vacated in the absence of any concomitant act to be performed by the jurisdictional deputy commissioner or by the competent authority in the government to accept such letter of resignation or such letter of withdrawal of resignation as the case may be. The petitioner has asserted to the effect that apart from sending the letter of withdrawal of resignation to the jurisdictional deputy commissioner, he had sent an email to the Panchayat and Rural Development Government of Assam in its email account, so and so, on the same letter of withdrawal of resignation on 2/10/2021. In this email, Lordship, he addressed it to the deputy commissioner, not to the government. With such assertion, the petitioner has contended that he had performed the process required on his part to withdraw his resignation, by sending the letter of withdrawal of resignation to the government in the Panchayat and Rural Development Department within the stipulated period, that is, within period of 15 days from the date of submission of the letter of resignation on 18/9/2021. The respondent number 1 in his affidavit has not denied about sending the letter dated 2/10/2021 in the official website of the Panchayat and Rural Development Department on 2/10/2021. That is a Sunday, Lordship, again.
No.
That is not a issue, but I am just saying,
was third. That is what the
yes,
observation is.
yes. Third was a Sunday. This was the Gandhi Jayanti.
Gandhi Jayanti.
Gandhi Jayanti.
Yes.
A stand was also taken to the effect that on 2nd October 2021 was a holiday being Gandhi Jayanti and the next day 3/10 being Sunday. The letter dated 2/10/2021 was received after resumption of the normal office hour. No dispute about all these things. It has been pointed out that the signed copy of the letter of withdrawal of resignation forwarded by the Deputy Commissioner Karimganj was received only on
2017.
2017. By such, because this letter, it was the same Deputy Commissioner. There is another letter he had addressed, which he has annexed in the writ petition of 1st October, addressed to the proper authority,
Mhm.
but that he did not send on that day. He came to the office on 8th, after expiry of 4th. He came to the office, and that is the disputed fact.
Mhm.
In our affidavit, we have taken a very categorical stand that the actual proper withdrawal letter, which he has drafted later,
Mhm.
he came to the office and submitted, and our dispatch record shows it was submitted on that day in the office at Dispur on 10th October. On 2nd,
8 to 10.
oh, sorry, 8th October, sorry, 8/10.
Second day, there was only a mail.
Mail addressed to the Deputy Commissioner. Deputy Commissioner is
Sent
not
to whom?
addressed to the Deputy Commissioner.
Sent to whom?
It
Was
was,
sent to whom?
it was, it was officially it was sent, but it was not addressed. It has to be written to the government. The Act stipulates that in certain situations, the Act says regarding Gaon Panchayat, it should be the Deputy Commissioner.
Mm.
In Jilla Parishad, it is specifically for resignation, it is Deputy Commissioner, for withdrawal, it is government.
Mm.
There are different scheme of things at different levels, Lordship.
Yes, yes.
By such stand, a plea has been sought to be raised on behalf of the state respondents that the act of withdrawal of resignation letter performed by the petitioner was beyond the period of 15 days from 8/10/2021. As such, in the considered view of this court, it is not tenable because the governing statute has cast an obligation to the holder of the office of the president of Jilla Parishad only to send the letter of withdrawal of resignation to the government within 15 days from the date of submission of the letter of resignation, 19(1). By sending the letter of withdrawal of resignation to the email account of government in the Panchayat and Rural Development Department, the petitioner has taken the requisite steps as may be reasonably required on his part to inform about his intention to withdraw his earlier letter of resignation to the government in ordinary course of 15 days period from time period, and it is another matter whether or not the fact that such withdrawal resignation had actually been known or not known to the government within 15 days period of time. Because the act of withdrawal of resignation also being of unilateral character, the condition laid down in 72(1) of the Panchayat Act is fulfilled when the holder of the office of the president of a Jilla Parishad takes the necessary steps for sending the letter of withdrawal of resignation within the stipulated period by ensuring that it reaches the proper destination, that is the government, in course of time. The court is also not oblivious of the proposition that a provision relating to giving or sending a notice calling for liberal interpretation for the person who has the statutory obligation of giving or sending a notice because he is presumed to be loser in the process, and it is for the safeguard of his interest, the very provision has been incorporated in the statute. In the case in hand, the petitioner has been seen to have performed the act of sending the letter of withdrawal of resignation to the government within 15 days. Sending the letter to the government, it is okay. But whether he has written to the government, that is what I would like to
Your
emphasize.
argument thrust is that since the email was addressed to the Deputy Commissioner.
Deputy Commissioner, it is not
could not
government.
have been branded as a
Yes.
resignation, withdrawal of resignation
Yes,
sent to the government.
yes, I have a specific case on this. When it is government from Himachal Pradesh, it should be the principal secretary of the department. I'll place a little bit later. Let me complete
Carry
this.
on, carry on.
Yes.
Yes.
In the case in hand, the petitioner has been seen to have been performed the act of sending the letter of withdrawal of resignation to the government within 15 days from the date of submission of earlier letter of resignation on 18/9/2021 by sending the email to the email account of government, that is so and so, at 12:35 PM on 2nd October 2021. The email was sent under the subject withdrawal of resignation from the post of President Jilla Parishad Karimganj. From the discussion made above, it is already found that the time period available to the petitioner's disposal to withdraw his letter of resignation was up to 4th October, and the petitioner had performed the act of withdrawal of resignation within the stipulated time period. Though a question in regard of admissibility of the letter of withdrawal of resignation sent by email on 2nd October has been raised, but acknowledgement received of the signed copy of the letter at a later date by respondent number 1 in its affidavit has substantiated the fact that sending the letter of withdrawal of resignation by the petitioner within the stipulated period of 15 days. Thus, the decision referred to the learned departmental counsel on the admissibility or otherwise appears to be not of relevance for the case in hand. If in such a view of the matter, this court is of the considered view that the office of the president of Karimganj Jilla Parishad did not cease to have vacated by the petitioner at any point of time, contrary to the view held by the state respondent authorities. So now, this is the basic finding that the Honorable Court completely relied upon the email received on 2nd. On that basis, the withdrawal was considered to be valid. Now, if I am allowed to place the 3 documents plus the relevant provisions of law.
Sure. Please see.
Subsequently, that is regarding no confidence, so we are not on that. We are specifically on the point of
Your
whether
argument is
procedure,
to
due
who?
procedure was followed or not.
Procedural,
Yes,
lacuna or not, whether the email addressed to Deputy Commissioner
yes,
forwarded even to the government
yes.
through mail would constitute a valid withdrawal. That is
Document
what
or
you
not.
are.
That is the case, Lordship.
Yes.
And the other hand, this letter of 1st October, which we have annexed, and they are also relying, but learned single judge did not consider it
No, that's not considered.
because that was a proper letter, but it was delayed.
Never followed, never forwarded.
Never acted upon.
Never.
The learned single judge did not consider that. Although it is disputed, according to them, they sent it on 1st. According to us, they submitted on 8th. So as the learned single judge has not entered into that area, that disputed fact, if at all is to be considered by this honorable court, then they will have to go to a civil court. They have to prove that it was sent. Whether
Have they-
received is
have
not
they-
important.
Have they, you, in this appeal, have they filed this, you must have taken this ground, that the 1st October was never forwarded?
Yeah, it was always in our affidavit.
It is already there.
It is
And
already
did
there.
they-
May I place our affidavit?
Hold on, please. Mr. Saikia,
Lordship.
did they counter that assertion of yours?
They are silent. They are basically silent.
Let's read that. Let's read that. So that at least that.
Yes,
temper of one
yes,
time-
I have
be put aside.
the reply also.
Yes, let's see your affidavit in
Yes.
opposition
Yes,
and their affidavit.
and their
in reply.
reply.
Yes.
Our affidavit. Paragraph
Let's first see their,
96, no?
their pleading in the writ
Yes.
petition regarding 110.
One thing, they are
When did
pleading.
they forward it?
Yes.
Is there any pleading?
Yes, Lordship, there is a pleading.
Uh,
Yes. Page 29,
hmm.
sorry, then I can read.
Yes, that is right, para 5.
Para 5.
But what is the mode of forwarding? They are silent.
It is on 110, the petitioner submitted a communication for withdrawal of his resignation dated so and so
Okay.
due to public demand as well as request from the members of Karimganj Jilla Parishad before the principal secretary of government of Assam
Hmm.
with a prayer to allow him to continue as president. This letter he has very nicely written.
Now
Yes.
let's see your affidavit in opposition because the question will
Yes,
be,
what is our response to file?
yes, then we'll pose a
Yes.
question which the
Yes,
other side has to
97.
answer. The other side has to answer.
Yes. The statements made in paragraph 5 of the petition, your humble deponent begs to state that the office of the deponent received the withdrawal of the resignation letter so and so from the petitioner. By DY number so and so
Read page 107,
107.
para 7 of your
There,
affidavit in opposition. Para 7.
this is their reply.
No, this is your affidavit in
So,
opposition.
huh?
Para,
This is not my, this is private respondents, Lordship.
this is
This is
private.
private respondent.
It's your
Mine is very categorical, page 97.
97, let's see.
The office of your deponent received the withdrawal resignation letter dated 1/10/2021 from the petitioner. Very categorically. From the petitioner by
Only
DY
one-
number so and so dated 8/10 after the
You
expiry of
also mentioned inward number.
Lordship. Docket number we have mentioned.
Yes.
Then their response to this, they have given a reply also.
Let's see.
Reply to law. Reply, it starts from page 24, then paragraph 5,
Yes.
paragraph 7. Paragraph 7,
Page 131.
155.
Page
125, Lordship.
131.
131.
That is preliminary contention
This
to
is,
subclause 1.
this is maybe to the others reply, the private respondents reply. 131,
Respond number, no. This is regarding affidavit in opposition filed on behalf of the respondent number 1.
that is in page 124.
Maybe there is a paging error. You read, please.
Yes.
This is, though they have addressed it as a affidavit in opposition against,
Yes.
reply against your affidavit.
Paragraph 4.
Yes.
I'm reading, Lordship. While denying the statements made in paragraph 7 of the affidavit in opposition, the answering deponent begs to state that having regard to section 9 and 10 of the General Clauses Act, 15 days time contemplated in 72 subsection 1 expires on 4th October. In view of the fact that 2nd October being a holiday on the occasion of Gandhi Jayanti and 3rd being Sunday. Therefore, the withdrawal resignation letter dated 1/10/2021 have been sent to the government within the stipulated period of 15 days, that is 4/10/2021. The government is bound to accept it considering the language and mandate of section 2072(1) of the Panchayat Act. It is pertinent to mention that the receipt of the said withdrawal letter dated so and so is not disputed by the government.
You have stated that it was received on 8th October.
We have received,
Pertinent.
but he is not category, he is not saying. He is giving a very vague reply.
Then there is
Therefore, what is most important?
one question that if he had already submitted it on 1st October, what was the reason to send a mail to the
Exactly.
junior
And in
officer,
Yes,
subordinate
and
officer?
number 2, in the 2nd October's
Second
email, he has not given any reference of the first.
That last time we observed that.
Yes, Lordships. Now, because this is the basic facts.
So now
So
your
now what is the
argument,
law?
basically you can focus whether the mail sent, though addressed to the deputy commissioner, sent to
Received
the
by
government
government,
would not constitute a withdrawal. That is what.
withdrawal
they are-
under section 72,
Which I-
1.
Come-
72,
come on
1.
that. Yes,
May I place it, Lordship?
yes, please.
72, Lord. Appeal for Gaon Panchayat or Baki Gizar.
Section.
72, subsection 1.
Just.
Resignation or removal of the president and vice president. Have Lordship. A member holding the office of president of the Jilla Parishad may resign his office at any time by writing and send it to the government through the deputy commissioner, and the vice president of the Jilla Parishad may resign his office at any time by writing and send it to the president of the Jilla Parishad, and in absence of the president, to the government through the deputy commissioner, and the office shall become vacant on expiry of 15 days from the date of such resignation, unless within the said period of 15 days, he withdraws such resignation by writing and send it to the government. So by writing to the government and send it to the government, there are two components here, two events. One, he has to write to the government. One, he has to send it to the government without the interference of deputy commissioner's office.
Right.
And to the president in respect of vice. This is my case. Now, regarding government, what the Honorable Supreme Court says in interpreting the Himachal Pradesh Act. 1990. Uh, 1993 two Supreme Court cases 725. List of books, sir.
You provided the list.
Yes, Lordship. 725. আর পঞ্চায়েত একটা বাকি class. And before going to that judgment, Lordship, the other two situations where withdrawal is contemplated and resignation is contemplated regarding
Analogous provisions.
based
What are you referring to?
in respect of Gaon Panchayat, there is a procedure whom to be addressed.
So there is a
And-
stipulated procedure for
Stipulated
every,
procedure for
every
every
post,
stages.
every post. Yes.
Like for resignation or removal of president or vice president of the Panchayat.
And that distinction is marked in every provision. There's a
The-
marked distinction.
Mark this, and there's a reason also that there should not be any coercion, any unfairness in the withdrawal or
Okay,
resignation.
now let's see this
The judgment.
judgment.
I'd like to place 3-4 paragraphs from this judgment.
Sure.
Paragraph 16. As pointed out by this court, resignation means the spontaneous relinquishment of one's own right, and in relation to an office, it connotes the act of giving up or relinquishing the office. It has been held that in the general juristic sense, in order to constitute a complete and operative resignation, there must be the intention to give up or relinquish the office and the concomitant act of its relinquishment. It has been observed that the act of relinquishment may take different forms or assume an unilateral or bilateral character, depending upon the nature of the office and conditions governing it. So there are certain conditions. So one condition is that they have to write to the government.
Hmm.
If the act of relinquishment is of unilateral character, it comes into effect when such an act indicating the intention to relinquish the office is communicated to the competent authority. The authority is also competent authority, Lord.
Hmm.
The authority to whom the act of relinquishment is communicated is not required to take any action, and the relinquishment takes effect from the date of such communication, where the resignation is intended to operate in presente. A resignation may also be prospective if the operative from a future date, and in that event, it would take effect from the date indicated therein and not from the date of communication. In cases where the act of relinquishment is of a bilateral character, the communication of the intention to relinquish by itself would not be sufficient to result relinquishment of the office, and some action is required to be taken on such communication. That situation is not envisaged in our case. Of the intention to relinquish, acceptance of the said request to relinquish office, and in such a case, the relinquishment does not become effective or operative till such action is taken. As to whether the act of relinquishment of an office is unilateral or bilateral, that character would depend upon the nature of the office and conditions laid thereto. There are various situations discussed. Now coming to paragraph 21.
Hmm.
The question whether the resignation of Karan Singh from the office of chairman of the board was required to be
This is on regarding unilateral, bilateral.
later, but writing to the government, what is I'm trying to emphasize, resignation by office from the members. Any member may resign his office by giving notice in writing to the government of Himachal Pradesh.
Hmm.
And next page, Lordship will see this interpretation
Hmm.
in the middle
Hmm.
after C. Office of the chairman board is unilateral character, and the resignation from the said office takes effect when it is communicated without any further action being required to be taken on the same. Since the chairman of the board is nominated by the government of Himachal Pradesh under section 4(2) of the act, the resignation has also to be communicated to the government of Himachal Pradesh. That is head of the department dealing with the board.
Hmm.
So that is where I'm emphasizing that it said it should be addressed to the principal secretary, which he has done in his letter of first
Mm.
October. He knows it, but he missed the bus.
Hmm.
Now, this is the law. This is a general law. Specific law of the same situation, more or less the identical situation happened in Maharashtra,
Hmm.
and the division bench of Bombay High Court Lordship passed 2 odd judgments. One judgment I'd like to place.
Let's see.
This is reported in Lordship. Copy to print for yes. Yes.
I've given,
The party's name is Maharashtra Jilla Parishad Councillors and Panchayat Samitis member. Resignation rules, so that is related to that. Dhanu Sangh versus State of Maharashtra. Dhanu Singh versus State
you
of.
don't have a citation, you could have given the copy.
Yes, Lordship.
If the citation is not there, how are we have to look at it? Problem is,
Yeah, or maybe the high courts are not there.
no, everything is there, but the citation you have not given.
Oh,
Problem is,
we have already mailed it, Lordship.
Okay.
Specifically, the procedure, these procedures of withdrawal,
if
they are also,
statute-
it was addressed,
that is a principle enunciated in A.K. Roy, the Constitution Bench,
Lordship.
85 Supreme Court,
Yes, Lord.
that if an act is required to be done in a particular manner,
Exactly.
it is required to be done in the very same manner and otherwise not
Yes, that Taylor versus Taylor, that law.
precisely.
So to that effect also, I would like to place one judgment, very recent one. So this case, Lordship, that it was addressed to the, not to the chairman, to the BDO. It has to be addressed to the BDO for resignation. So it was not considered to be a valid resignation. Same spirit is regarding the withdrawal also. Squarely covers our case, Lordship.
Is there no?
So, Lordship may keep it, Lordship, because
No,
I'm not,
it's okay. You've got a copy.
Lordship.
Yes,
May I place this Bombay High Court's order?
yes. This is what you just handed it over to us, huh?
Yes, Lordship.
Okay.
Citation, I am just putting.
Hmm.
Online. 2011, volume 4, Maharashtra
Law Journal.
Law Journal. But I read it in online, SCC online, Bombay. But I cited.
Then it's,
Anyway, Lordship.
they'll get a print, not an issue.
No, no, even my printout is of this. But anyway, Lordship,
Yes.
here,
Okay, next, what next, Mr. Saikia? Hmm?
paragraph 11 onwards.
Yes. Read, please read.
Yes, Lordship. Section 60 of the Act of 1961 provides that the procedure for tendering resignation as member of Panchayat Samiti and to whom it should be addressed and handed over. Section 60 contemplates that any member of Panchayat Samiti may resign his office by writing under his hand, addressed to the chairman of the Panchayat Samiti, and on tendering such resignation as per the procedure stipulated in Section 60 by the members of the Panchayat Samiti. The office of such member shall become vacant. Rule 3 of the Rules 62 stipulates that letter of resignation by the members of Panchayat Samiti shall be tendered to the appropriate authority, that is chairman of Panchayat Samiti, as mentioned in Rule 2B4 of the Rules of 1962, either by delivering it personally or through any persons duly authorized by him in this behalf or by the registered post acknowledgement due. Similarly, Rule 6.1 of the Rules of 1962 stipulates that on receipt of the letter of resignation, the appropriate authority, that is the chairman of Panchayat Samiti, shall forthwith acknowledge the same, and such acknowledgement shall specify the time and date on which the letter of resignation was received. 6.2 makes it obligatory on the appropriate authority to inform the persons tendering the resignation in writing by registered post, acknowledgement due, the date from which the resignation shall become effective under Rule 4. Rule 4 of the Rules of 1962 contemplates that resignation tendered under Rule 3 shall take effect from the 7th day from the date of on which it is received by the appropriate authority. In the instant case, it is not in dispute that the petitioner are alleged to have submitted their resignation to Block Development Officer Panchayat Samiti, Mahagaon, and not to the chairman of Panchayat Samiti as required under Rule 3. Skipping all this, Lordship.
Paragraph 15 is the relevant.
Yes, paragraph 15, Lordship. I have highlighted here.
So that 7 days is not relevant for us.
Those are also, the only thing is that addressing authority.
Address to the proper authority.
Proper authority. In the instant case, the letter of resignation were alleged to have been tendered by the petitioner 2312 and the respondent number 3 give effect to them from the same date. This act of the respondent number 3 is in complete violation of Rule 4 of the 62 rules, which contemplates a resignation tendered under Rule 3 shall.
Which
affect
other
on the-
judgment, Mr. Saike, we have read this.
Yes,
Which other judgment?
the other judgment is lordship is 2022-7-9 SCC page 23. That same the things has to be done in a particular way and no other way that Nazir Ahmed's case cited. So this is a recent one. Series of judgments are there. Yeah, paragraph. Paragraph 14. Page 28, lordship, it is a part of paragraph 14. In Nazir Ahmed's case, the judicial committee observed that the principle applied in Taylor versus Taylor to a court, namely that where a power is given to do a certain things in a certain manner way, the things must be done in that way and not at all, or not at all, and that other methods of performance are necessarily forbidden, applied to judicial officers making a record under section 164, and therefore held that the magistrate could not have given oral evidence of the confessions made to him, etc. 8. The rule adopted in Taylor versus Taylor is well recognized and is founded on sound principles. Its result is that if a statute has conferred a power to do an act and has laid down the method in which the power has to be exercised, it necessarily prohibits the doing of that act in any other manner than that which has been prescribed. The principle behind the rule is that if this were not so, the statutory provisions might as well not have been enacted. A magistrate therefore cannot in the course of investigation record a confession except in the manner laid down in section 164. So that later, lordship, I'd like to place just before concluding.
Email,
Email and the 1st October.
1st
statement.
October,
Email to.
annexures 5, 6, 7.
Yes.
Hmm.
Lordship will see that email government letter.
Annexure 5, 6, 7 to the writ petition. The letter is at
Yes.
page 81.
It was at
81.
at page 82, annexure 5. This is to the deputy commissioner.
No,
That-
you are first referring to the 1st October letter. That is at page 81. Which
81.
as per you
Yes.
was
Yes.
presented on 18th October.
Yes, lordship. Now
Hmm.
it was presented on 8th October.
8th October
8th
as per
October.
you.
This letter,
Because-
page 81. Lordship will kindly see resignation. Here reference is
Hmm.
resignation letter 18-9, communication so and so 18-9 from the deputy commissioner. He has given full reference
Hmm.
and he wrote this letter. There is no receipt, nothing on that
Yes,
letter.
that we have seen. That-
And next page, lordship, the email part, which we have annexed, which he has annexed.
In which
2nd
that
October.
in email, he has scanned this
Yes,
letter at annexure.
and it received.
Page
Even-
83.
Even I am accepting, lordship. It
That
was
of course,
received within
email,
court.
there will be a proof of receipt otherwise also.
Yes,
But
there
that
is no
letter-
dispute on that.
Even what he has annexed with the petition, the email reveals that it is an scanned copy of this annexure,
Yes, page, that
at
is at page
83.
84.
page 83.
83 is that his own handwriting.
Yeah.
Type copy is at 82. And next is that email. Receipt of the email at
Yes.
page 84.
All right.
2nd October 1:35 PM, delivered 2nd October 11:54 AM.
Yes. Mm.
85 to email. 85 to email.
In any case, lordship, we are not on receipt here. The receipt is to whom it has been addressed.
Yes.
So it has been addressed the letter of 2nd October.
Yes.
Subject withdrawal of the resignation from the post of president of Karimganj Jilla Parishad, Karimganj. I have the honor to inform you that I have submitted resignation from the post of president of Jilla Karimganj Jilla Parishad on 18-9. For the interest of public, I would like to withdraw my resignation from the post of president, so and so, dated 2nd October.
Mm.
There is no reference. If he
Of
had
1st October.
of 1st October, and
There was no need. As a matter of fact, if 1st October was already submitted,
then
he
what
was
is the
from-
requirement?
he was aware of the law that it has to be addressed to the government.
In
and-
all probability, he must have gone to the advocate and because here 72, all these sections are also referred. Very detailed. May I read it, lordship?
Leave it, no problem.
Last paragraph.
The-
Therefore, in my humble request,
Significant fact is, number one, there is no reference of this letter
yes,
in the letter dated 2nd
Exactly.
October. And if this was forwarded,
Lordship.
there is no need as to why 2nd October should have been
Exactly, Lord.
disordered.
This is my case, Lordship.
Yes, yes.
My lord, before placing my case, I'll quickly respond, my lord, to the submissions of my learned senior.
Mm,
Firstly, my lord, in respect of the judgment relating to Nazir Ahmed's case,
mm.
which is, my lord, cited by my learned senior 22, that your lordship will take note of that this is in respect of exercise of power. Here, my lord, this is a situation totally different. I'll come to-
Those persons were saved
Well-
because they craftily drafted the letter and addressed it to the wrong authority.
My lord, I will-
That weighed with the High Court and the resignation letters were not acted upon. That is what the ratio is, that they are not addressed to the proper authority. So the acceptance would also not matter.
I'll come to that, my lord. Firstly, Nazir Ahmed, essentially, it relates to exercise of power. So therefore.
Something which is required to be done
Yes,
is required to be
that
done
is
in
in
that
respect-
manner and that manner.
Exactly, my lord. That is
So
in
that-
respect
If that is relating to exercise of power,
Power.
why not the same logic to exercise of duties?
Yes.
And you are also exercising your right. As a
I-
matter of fact,
Yes.
you are exercising your right to withdraw the resignation as stipulated under section 72.
I'll come to it, my lord.
Oh, yes.
Let me first respond to my learned senior's argument.
Yes.
Secondly, my lord, the judgments which are cited,
Mm.
those are relating to resignation in respect of a procedure where the bilateral procedure, my lord, is required. Because, my lord, the accepting authority is required to accept the resignation. Here is a case, my lord, under section 72, your lordship will kindly see, my lord, it's a unilateral, my lord, process. The honorable single judge has also held, my lord. So therefore, by way of a legal fiction, my lord, I am out of the office the moment, my lord, 15 days has expired. So in that context, my lord, your lordship will consider my case.
Mm.
Thirdly, my lord, my respectful submission is, even if, my lord, my letter is not addressed
Mm.
to the government, your lordship will consider that the essence of section 72
Mm.
having been complied with, my lord, that the withdrawal letter. is
Why?
before
Why is
expiry-
the essence complied with, sir?
My lord,
Why
My-
is this essence? Why
lord,
is
my-
just tell us,
No.
why is the principal secretary required to take cognizance of your letter, which is not even addressed to him?
I'll quickly, my lord, I'll respond to lordship's, my lord, query. My lord, here is a case where your lordship will apply the doctrine of substantial compliance.
Mm.
My lord, I'll place two judgments.
Yes.
When, my lord, a particular enactment is comprised of a mandatory part and a directory part, the mandatory part has to be scrupulously followed.
Mm.
And even if any deviation, my lord, is in respect of the directory part, that your lordship will ignore. My lord, I'm directly coming to, my lord, the judgment, Raza Bulan Sugar's case, my lord.
Mm.
Here what has happened, my lord? Citation to whole 1965, Supreme Court 895. My lord, here what has happened, it's an interesting case.
Yes.
In Uttar Pradesh, my lord, there is a place called Rampur.
Mm.
And there is an act, my lord, UP Municipality Act 1916.
Mm.
Now, under section 131, the act empowers, my lord, the local municipal board to impose tax.
Mm.
And the requirement is, my lord, that the board will draft, my lord, make a draft rules and it will publish. And there is another requirement under section 93 that the manner of, my lord, publication is, my lord, discussed, my lord.
Mm.
What is required is it should be published in a local newspaper and the newspaper should be Hindi. My lord, what was done? It was published, my lord, in the local newspaper, but it was not a Hindi newspaper.
Mm.
Then the appellant went to the apex court saying that, my lord, the procedure is vitiated, so therefore the municipal board loses its jurisdiction, my lord, to impose the tax.
Mm.
Now, what the apex court has said, your lordship will kindly come to para, my lord, 11. Another Supreme Court judgment, my lord, is also discussed here in my lord. Para 11, I'm taking your lordship directly to para 11. Lordship has got it, my lord. Turning now to the second part, which provides for the manner of publication. That manner is provided in section 94(3), already set out above. It seems as to that the legislature provided for the manner of publication, it did not intend that the manner should be mandatory.
So that is the distinguishing feature, sir. Therein the Honorable Supreme Court went on to hold that the direction given in 94(3) was not mandatory. In
No.
that situation, obviously,
No,
if there is some deviation,
my lord, I'm reading.
that has to be ignored.
Lordship, kindly allow me to read paragraph 11, my lord, then
Yes,
everything will become clear.
read, please.
So long as publication is made in substantial compliance with manner provided in section 94(3), that would serve the purpose of the mandatory part of section which provides for publication. It would therefore be not improper to hold that the manner of publication provided in section 94(3) is directory, and so long there is substantial compliance with the purpose of the mandatory part of section 131(3) would be served. In this connection, this is important, my lord, that another Supreme Court judgment has been referred. In this connection, we may refer to Kamaraj Nadar versus Kunja. In that case, a question arose whether section 117 of the Representation of People Act was mandatory or directory. That section required that the petitioner filing an election petition had to enclose with petition a government treasury receipt showing that a deposit of 1,000 rupees had been made by him either in a government treasury or in the Reserve Bank of India in favor of the Secretary to the Election Commission as security for the cost of petition. This court analyzed this provision and observed that it consists of three parts, namely, the government treasury receipt must show such deposit has been actually made in the government treasury or in the Reserve Bank of India. Number two, it must also show that it had been made in favor of, next page, my lord, favor of the Secretary to the Election Commission, and it must further show that it had been made as security for the cost of the petition. The question then arose whether the words in favor of the Secretary to the Election Commission were mandatory in character, so that if the deposit had not been made in favor of the Secretary to the Election Commission as therein specified, the deposit, even though made in government treasury or in the Reserve Bank of India and as the security for the cost of the petition, would be invalid and of no avail. This court held that these words in section 117 were directory and not mandatory in their character, and the essence of the provision contained in 117 was that the petitioner should furnish security for the cost of the petition and should enclose along with the petition of government treasury receipt showing that the deposit of 1,000 rupees had been made by him either in a government treasury or in the Reserve Bank of India to be at the disposal of the Election Commission to be utilized by it in the manner authorized by law and was under its control and payable on a proper application being made in that behalf to the Election Commission or to any person duly authorized by it to receive the same, be he the Secretary of Election Commission or anyone else. The Honorable Supreme Court said the mandatory part is the security amount should be received by the government. Then, my lord, if this essential requirement was complied with, no literal compliance was at all necessary with the words in favor of the Secretary of the Election Commission. This was omitting, my lord, appearing in that section.
Have you seen the facts of that case? What was the deviation? Have you noted? The notice was published in Hindi. The only defect was newspaper was in Urdu. How would it make a difference?
Yes, notice was yes, that is what I'm trying to say.
Read 94.3 then. Read 94.3. What is it required?
Yes.
Can you find out
My
94.3?
lord, the notice was.
Can you find out 94.3 from this judgment?
Yes, 94 is there, my lord.
Let's read.
Yes, yes.
It only says local newspaper. So there was a substantial complaint.
Yes, 94.3, your lordship will find at para 6.
Yes.
No,
It's not there, sir.
I'll
But what you stated,
Yes.
we presume that is the publication has to be in a local newspaper. So
publication.
the publication language of the newspaper was not relevant. Language of the notice, the notice was required to be published in Hindi, which was complied.
Exactly, my lord. That is what I'm trying to say. My lord,
There was no deviation with the statutory requirement at all.
what I'm trying
That
to say,
judgment is not applicable.
my lord,
Next case, please. Next judgment.
my lord, my next judgment is in respect of, my lord, same substantial doctrine of substantial compliance.
Yes.
My lord, the Honorable Supreme Court has discussed, my lord.
Mm,
Your lordship will take up this one.
yes.
2011, 1/60, 236.
Yes.
My lord, will come to para 32. The doctrine of substantial compliance is a judicial invention, equitable in manner, designed to avoid hardship in case where a party does all that can reasonably expected of it, but failed or faulted in some minor or inconsequential aspects, which cannot be described as the essence or the substance of the requirement. Like the concept of reasonableness, the acceptance or otherwise of a plea of substantial compliance depends upon the facts and circumstances of each case and the purpose and object to be achieved. And the purpose and object to be achieved, lordship will kindly see, and the context of the prerequisites which are essential to achieve the object and purpose of the rule or the regulation. such a defense cannot be pleaded if a clear statutory prerequisite which effectuates the object and the purpose of the statute has not been met. Certainly, it means
The
that.
last four lines of this para, substantial compliance means
Yes,
actual compliance in respect to the substance essential to every reasonable objective
of the
of the
statute.
statute
Yes. And the court should determine whether the statute has been followed sufficiently
sufficiently.
so as to carry
Yes.
out the intent of the statute and accomplish the reasonable objective for which it was passed. Now, going to section 72, my respectful submission is, my lord, there are two mandatory parts. Firstly, my lord, the withdrawal has to be made before expiry of the
15
15 days.
days, yes.
And the second, my lord, requirement is one should send, my lord, it to the government.
Hmm.
Now, the question is, my lord, if I have withdrawn it admittedly before expiry of 15 days and send it to the government, whether or not I have followed, my lord, with the, my lord, mandatory part of section 72. Now, so far as, my lord, addressing to the deputy commissioner is concerned, that will not vitiate, my lord, my act.
The principal secretary or the government may be very well entitled to take a view that there is no intent to communicate the withdrawal to the government. That is why it is craftily drafted. That is how things happen. You keep a slight defect that acts as a defense in future litigation. That is how things go. Your own letter dated 110 shows your intent.
My lord, I'm coming to 110 letter, my lord,
Yes.
this argument that it was submitted on 810.
You tell us
that is not correct.
just hold on.
Yes.
What have you pleaded in your petition regarding the mode in which it was submitted?
Paragraph 5, my lord, in the
Read-
writ petition, we have stated.
You tell us, we have read it. How was it submitted? By
Page
hand,
29,
by post, by registered ID? How?
it was submitted in the office, my lord.
Read. These are writ petition proceedings, sir. You have to be very specific in your pleadings.
Yes, my lord, I'll come to that. 11021, the petitioner submitted a communication for withdrawal of his resignation letter 8921 due to public demand as well as request from the members of Karimganj Jilla Parishad before the principal secretary, the government of Assam.
How,
Panchayat and Rural Development with a prayer to allow him to continue a president.
how
of
was
Jilla
it
Parishad.
submitted?
Now, Lordship,
They have disputed it.
Yes.
What have you said? in
I'll
it?
show it, my lord, from the records. Your Lordship will kindly come to, my lord.
Mr. Talukdar, just answer one question. If 110 letter was submitted, what prompted you to forward a mail on second?
Yes, I'll quickly respond to your
Yes.
Lordship. My lord, this particular letter,
Hmm.
my lord, since we did not have any acknowledgement, my lord, so therefore, this on the second day, my lord, it was sent to deputy governor. Lordship will kindly see, my lord,
Why didn't you scan
letter-
why didn't you scan the 1st October letter and send it to the?
that is an
principal?
inadvertence, my lord. My
Yes.
lord will kindly see this particular letter.
That
110.
gives rise to an inference that it was created later.
No, my lord, this particular letter of 110 is a part of the writ petition which was filed on 7th, my lord. Your Lordship will come to here, my lord, come to this writ petition, my lord.
Yes, so what of that? What of that?
My lord, the argument that it was.
Forget about that. Forget about that for the time being. If at all you had sent a letter on 1st October, why didn't your letter dated 2nd October have that recital that I have already submitted a letter physically in your office?
My lord, in that case, my lord, my respectful submission is 2nd October letter,
Mhm.
my lord, in terms of 72. is not-
That is an arguable
my
issue.
lord, it- No,
And
no. it
for
is
that
not-
purpose
no,
that it
Lordship will
requires.
kindly see, the last
Yes.
date of withdrawal, my lord, is 4th. It is admitted.
Yes,
So 2nd October letter, my lord.
that is
not
a
invalid, my lord.
seriously arguable question.
No,
Then the
Lordship
matter
will-
requires admission. Yes. Admit issue notice.
It was all, it is for final disposal, Lordship.
The final disposal, Mr. Saikia, will not be possible right now. Little difficult.
And in that case, then Lordship, I am praying for staying of the learned single judge's order.
Yes, that's an argument. You have a prayer?
Yeah, we have a prayer and initially status quo order was passed. He
Yes.
was restored
My
back.
lord- my
Now
lord will-
today, Lordship, he has no right to
My
continue.
lord will kindly allow
The
me
same,
one
just
submission.
same,
My lord, if your Lordship allows me one submission, my lord.
because
Only
there
one
was a,
submission. My lord will kindly see.
Hmm.
My lord, there is another order. If I take your Lordship's, my lord, to order at page 88.
Hmm.
Lordship will see how things proceeded, my lord.
Hmm.
Page 88
Of,
of, my lord, the writ appeal filed by the state.
yes.
This is a writ petition filed by the petitioner.
Hmm.
Now, this, my lord, writ petition was filed challenging an order of the deputy commissioner. He wanted to intervene. Now, page 89, the honorable single judge, my lord, it narrated the facts. Then your Lordship will come to page 90.
Hmm.
The, my lord, third paragraph. List on 28 and 21,
Hmm.
enabling the respondent one principal secretary to the government of Assam in PRD department of the state to apprise the court as to when the petitioner submitted his application for withdrawal of his resignation letter dated 18/9/21 noted above,
Hmm.
petitioner shall serve so and so in the interim
Hmm.
till the returnable date 28/10/21. The communication dated 5/10/21 of the Deputy Commissioner Karimganj shall remain suspended. Now your lordship will see this is an order of 8/10.
Hmm.
Barely from my lord, barely 3 days therefrom, at page 93, my lord, the principal secretary had passed the order
Hmm.
ousting me from the office without even referring my lord to this order
Was
of
it
the honorable.
required? Was it required? As you have read the judgments, it's a unilateral act. There is not even a requirement of these orders.
That is what I'm trying to say, my lord. Your lordship will kindly see. With reference
We'll
to your
ignore
letter.
it, then we'll ignore this order. These are technical laws, Mr. Talukdar.
Well,
There
by
should
way
be-
of this order, I was ousted from office, my lord.
Yes, there was no need.
Exactly, my
There
lord.
were no need. That's what we are saying. We'll reiterate that.
My lord, in
Where was
fact,
the
this
need of passing a formal order?
Well,
In
this
fact,
is-
lordship, what happened on 18th, he submitted the resignation. The no confidence exercise was to be taken on 20th. Just prior to that,
We understand that.
this is the way.
We understand. That's a ploy.
That's a ploy. And the Honorable Supreme
has
Court in
been taken
recent
care
of.
Thakkara's case,
by the honorable.
once you have resigned and you have not faced the floor test, you have no right to continue.
I'll face it, my lord. Right now, I'll face it. That has been, my lord, my lord, in fact, that has been upheld by this honorable single judge. That you
Yes.
go and face, my lord. I'll
Yes.
face it, my lord.
There shall be a stay on the order passed by the single bench.
Deeply obliged, lordship.
What about writ appeal number 291? What is that about?
That is private respondent, lordship. I am on for only for the state.
We are asking Mr. Mazumdar, what is it?
Lordship, in this case, I am appearing, Lordship. I am the Vice President, Lordship, and pursuant after his resignation, Lordship,
All right,
I have
then
been given the charge of
the
President.
consequences of passing a stay will follow, whatever is that. So your appeal will just continue. We'll admit your appeal also.
Lordship.
Admission notice. As the respondents are duly represented, notice need not, process need not be issued.
Obliged, my lord.
Highly obliged.
Most of the panchayat related matters are Karimganj. Yes. No confidence motion. Withdraw adjustment. This is-
Listed, he'll be listed for hearing. That's all simple. List for hearing.
Well, this
I
matter,
can approve.
this matter is an appeal by the, my lord, the government of Sikkim. It was transferred to your lordship's bench, my lord.
Yes.
My lord, pleadings are now complete. On the last occasion, I prayed for time, your lordship, but please to grant me time. Pleadings are now complete. My lord, the matter is yet to be admitted. Should I, my lord? As a matter is on
What do you say,
orders
Mr.
today.
You'll admit it. So it's listed for orders, it doesn't matter.
No, that's
Now
not the-
pleadings, it was, today it was listed for receiving your
some
some affidavit.
reply to our affidavit.
Yes, reply to.
Though we have not brought anything else as only as to judge.
There is
judgment of the
something
Supreme
filed by
Court. And
Senior
they have
Council
filed
on,
it.
today on
My lord,
26th,
may-
21st.
May I make one submission, my lord? It's a fact, my lord. If the matter is taken, it will take some time.
Yes,
So on reopening, if a lordships could kindly fix the date for disposal, my.
all right. On the,
Today also we are prepared, but likely to take some time, my. lord.
Yes, that I agree with my learned senior colleague.
on the submission made by land council, senior council representing the appellants and Mr. Chaudhary, land senior council representing the respondent, the appeals are admitted for hearing. There's two appeals, right?
Well, no, there is only one appeal.
Yeah,
One,
one is admitted for hearing. What is the IAS civil?
My lord, IAS losses can take care in the final hearing time also.
The prayer made in the interlocutory application shall be considered when the appeal is finally heard. Thus the IAS are disposed of.
My lord,
List for hearing in August.
my lord.
My lord, may kindly give a date, my. lord.
22nd August.
My lord. Deeply obliged, Joseph.
My lord, I'm told, my lord, if the matter is taken up in July, perhaps, my lord, our concerns can be addressed. Third week of July, my lord, if it is possible.
You have got many matters listed, Mr. Chaudhary. You just take a call whether you will be able to address the court in
Okay, my
all those
lord,
matters.
In the first week of August, kindly give a date, my lord.
My lord,
Because my learned
Mr.
friend will
Dev.
also come.
My lord, after 15th will be favorable for me.
All right, then
Why?
22nd.
You won't be independent before that.
Well, subjugated under you.
15th August, you'll read.
22nd. Let
Ten
us
seconds, 10 seconds. We'll take a call. Developly.
Item number 5.
It is your lordship. Lordship, this IA has been filed to implead the opposite parties as respondent number 4 and 5 in the connected contempt petition, lordship.
Interlocutory application submitted on by land counsel for the petitioner for impleading the officers presently holding the post of respondents numbers 4 and 5
Yes, lordship.
is accepted. Let notice be issued to the respondents in terms of the. You file an amended cause title, sir.
Lordship.
Where is the cause title? Wherein you have impleaded the concerned officers.
Lordship at page 5.
Response numbers 1 and 2 yoga. Officers impleading the present Chief General Manager Telecom and General Manager Telecom Assam Circle as party respondents in the contempt proceedings. Let notice of the contempt case be issued to such respondents.
Obliged, lordship.
Item number 6.
Steps for service be taken in 7 days, whereafter process be issued. Yes.
It's an application for condemnation, will your notice could go.
Issue notice to the respondents. Steps for service be taken in 7 days, whereafter process be issued. Rule is made returnable in 8 weeks.
Item number 7.
Please, your lordship. My lord, I'm appearing in person in this case. My lord, the electric supply of my premises were disconnected in gross violation of all the relevant rules and laws, my lord, which is applicable in the present case. My lord, in their affidavit itself, they have said that they disconnected temporarily under 8.3 of the regulations. My lord, that is, they have their own regulation, my lord, Assam Electricity Regulatory Commission, Regulation 2017. You know, if the regulation itself says, my lord, your lordship, I have reproduced the same at page number 15. My lord. You know, the supply may be disconnected temporarily in following cases. Where a person neglects to pay any charge for electricity or any other sum due from him in a licensee by the due case mentioned in the bill in respect of supply, transmission or distribution or wheeling of electricity to him, the licensee may, after giving not less than 15 clear days notice in writing, which they never did.
What do you say, Mr. Counsel? Please admit the appeal.
My lord, this matter has already been, with regard to the connection, it was already heard by the single judge, and the single judge.
Yeah, that's
My
my
lord,
appeal.
my lord,
So
may just-
he is in appeal.
Yes, my lord, I get it, but the issue that has been raised, my lord, here, my lord, may just go to page number 81 of the writ appeal, my lord.
What is the, what is?
My lord, the notice is saying that has not been complied with. With all the, along with all the electricity bill, my lord, under section, my lord, after the bill, under section 56(1) of the IE Act 2003, power supply to your premises will be disconnected at any time due to non-payment of area amount. So this notice was already been given with, along with the bill, as per section 56. Thereafter, my lord, may see the page number 82. It's another electricity bill there. Under section 56(1) of the IE Act, power supply to your premises will be disconnected at any time due to non-payment of ignore if already paid. So that this notice had been given to him
In every bill.
in every bill continuously. When he did not make the payment, we issued him a intimation to consumer after temporary disconnection of supply. As per the code, after you do temporary disconnection, we intimate them. We intimated them, he received it. After he received it, he gave us a legal notice, and his legal notice is part of his writ petition.
Where is
And-
that? Where is the legal notice?
Yes, my lord. My lord, at page 48.
Hmm.
My lord, at page 48, the legal notice is there. At page 49,
Yes.
that the power connection of the aforesaid unit was disconnected sometimes 2 years back by the office of the SDO so and so. However, even after disconnection of the electricity connection, the office of the SDO Jew Road continued to generate electricity bill. As my senior has been settled in money for so long, he was not aware of the fact the power connection has been disconnected, and even after disconnection, the office of Jew Road has been generating electricity. Anyway, we went to the office to inquire about the matter on 29/3/2022. We were told by a person who's sitting in the bill receipt, the same day was the last day for payment of it was to be reconnected. And apart from the bill, we have to pay an additional charge for reconnection free charges. And my lord, the moment he says this, and my lord now see at page 45. There's a distinction between both the bills. And this is as per the electricity code and the regulation. My lord may see this is a PDC bill. The PDC bill short form is permanent disconnection. We have told even before the single judge, even we have read in the first time that you apply for the fresh connection, we are going to give you connection. But he is only harping on the fact that he needs the old connection. Once the entire boat has been sailed, how can we give him a new connection, or the old connection on the basis of the papers that he has already webbed by? So he has to supply with the new papers and we'll give him a new electricity connection. And that is what the learned single judge is also.
That liberty has already been given.
Yes, and my lord, may I submit first? My lord, may look at page
So otherwise also,
page 11.
we'll admit your appeal. Be happy without the connection. What will happen? We'll admit your appeal. It will come up for hearing after 2 years. So we'll continue without electricity.
My lord,
We're not giving you interim relief.
my lord, may I
That is
just,
for sure.
may I just, my lord, take your lordship to page number 85.
We have seen the file, Mr.
My lord,
Rao.
page number 85, my lord.
All right.
Page number 85.
Very well.
My lord, this is the notice they are saying that they have served, which we were never served, but even admitting that it is served, my lord, presuming, my lord.
Yes.
Your lordship may kindly see, this is the date, 16/11/21. Yes, my lord. And we have kindly said, my lord, this is to inform you that supply has been temporarily disconnected with effect from
Yes.
28/20.
Yes.
My lord, this is, even if it is presumed to be issued, my lord, this was supposed to be issued format 18 within, my lord, 24 hours. They have issued after 15 months. And that also they
They have been sending you the bills with the notice.
The
bills, the notices,
I'm coming to
the
that.
notice
Page
is
number,
printed in the bills.
my lord, I'm coming to that. Page number 77, my lord.
Yes.
Page number 77, bill date, my lord. Your lordship may kindly see bill date 1/6/2020.
Yes.
Yes, my lord, this 1/6, this correction, my lord, this is saying disconnection notice under section 56(1) of the Electricity Act. Your supply to your presumed will be disconnected if any time due is not paid. My lord, this notice says even if it is assumed to be correct, then also this notice is for disconnection under section 56(1). And their disconnection is under their own regulation. Your lordship may kindly see their affidavit. What they have said in their affidavit, my lord. Your lordship may kindly see. My lord, they are contradicting themselves. Your lordship may kindly see their affidavit. My lord, page number 73.
Yes.
Page number 73, my lord.
Yes.
You know, it is pertinent to mention herein, my lord, it is pertinent to mention herein that the temporary connection of the petitioner premises was done as per 8(1) of the ARC 2017. Whereas this notice speaks of section 56(1).
All right.
And not only that, my lord, again, not only that. This page 77 and 78 was before the disconnection. But your lordship may kindly see page number 80. That this bill is still continued, this notice is still continued after the disconnection. Page number 80, my lord. Bill date may be issued, my lord. 2/9/2010. It was already disconnected as per their own version, as per their own counter affidavit. It was disconnected on 28/2020. Then where is the question of this notice for disconnection after the disconnection?
Yes.
Well, it is totally, they have violated all the relevant provisions. The notice is, even if it is this notice, several courts have held that this notice is not valid notice because they have to issue separate notice. Now, even otherwise, under section 171 of the Electricity Act. Now, even otherwise, my lord, even if this notice is for disconnection under section 56(1) of the Electricity Act. Whereas they themselves say in their affidavit that it was disconnected under their regulations, under their Assam Electricity Regulatory Commission Regulation 2017. This is what they themselves say. Then again, my lord, the intimation was to be made after disconnection within 24 hours. And they have said, they have issued it after 15 months. What was to be done within 24 hours? They have done after 15 months, my lord.
Sir, what was to be done? You have taken an electricity connection.
Yeah.
You lock up the room, go away.
No,
How
I
do
did
you,
not
how
go,
do,
my lord.
how are the bills to be paid?
My lord, they have to inform us.
You refrain from paying the bills and then you expect that every
No,
technical
I
aspect.
paid it. I paid it. Later on also, I paid it totally, everything. And then
Later on,
another single
later
just
on.
has said,
But for that period during which the notices were
Yes.
issued, the bills were sent.
Yes.
What was happening?
my lord, I have already paid, my lord. You will see, kindly see, those days, it was Corona, peak Corona period, my lord. It was during August, when the whole nation was under lockdown.
The bills are paid online.
No.
Need not go physically.
My lord, we did, that was,
Yes.
I'm from Manipur, my lord. Imphal.
Bills, yes,
And
the bills are paid through mobile, sir. There's
My
no
lord-
need of physically going.
My
You
lord,
get an intimation,
my
the
lord,
bills are sent
my lord, but
by message.
My lord, are they not supposed to issue notice, my lord? The under section
All right,
170
then we'll admit your opinion.
my lord,
we'll
171, you don't see, kindly see, my lord. You don't see, kindly pass
You-
entry model for disconnection,
Absolutely no, sir.
reconnection, my
You
lord.
want, you went, then we'll dismiss the prayer for interim relief by reason order.
My lord, interim prayer may kindly be ordered, my lord.
No, sir, sorry.
My lord, and then some order may pass on the interim prayer, my lord, because
All right. Yes, Mr. You argue on interim prayer.
Yes, my lord. My lord may go by page 105, my lord,
Yes.
of the, that is the part of the judgment. Same argument was placed before the honorable single judge.
Mm.
And the honorable single judge, after hearing, his submission has passed this. My lord, I have gone on to explain on how 56(1) is applicable under AERC. Under regulation 1, my lord, may I read?
Yes.
Under regulation 1.3.2, reference is made to the related provision of Electricity Act, section 50 among others related to recovery of electric charges, intervening of bill and electric charges, disconnection of non-payment of charges, section 56 relating to disconnection of supply in default of payment. Under section 50, the Electricity Act gives the state the power to go with the supply code. And by incorporating that under section 1.1, we incorporate section 56. And the one which is talking about the intimation. My lord, I have just given the book.
Yes.
My lord, may just see there at 8.1, temporary disconnection, my lord.
Yes.
The license shall intimate the consumer in case of his temporary disconnection in format 18 within 24 hours of disconnection. That is, after we temporarily disconnect, then only
Then you
we have
give
to
the
intimate
intimation.
that
Yes.
from when you have not been paying the bill. And my lord, for that, my lord may see 8.2, temporary connection. 8.2, temporary connection, my lord. Where a person neglects to pay any charge for electricity or any other sum due for him to have a license
8.2,
of the code, my lord.
temporary disconnection.
Yes, my lord.
Yes.
Where a person neglects to pay any charge of electricity or any other sum due from him to a licensee by the due date mentioned in the bill, in respect of supply, transmission, or distribution of wheeling of the electricity to him, the licensee may, after giving not less than 15 clear day notice in writing to such person and without prejudice his right to recover such charges or other sum by suit, cut off the supply of electricity under such charges or other sum together with any expense incurred by him in cutting off the election and are paid but not longer. So this 15 days is this section 8.2, the clause 8.2 is parameter with section 56 of the IE Act. So in IE Act also it says that you should give him 15 days notice. So we have given him 15 days notice, and this is not only with him. And all the bills that are issued to the customers of APDCL, the 15 days notice is reflected in the bill period itself. And now he is saying that no proper notice. My lord, nowadays in the 2020, when there was a COVID lockdown and everything, it was hard for people to come in. So that is why all the electricity bill was sent to their mobiles and to their internet connection, and that was there available. So, and my lord, electricity is a necessity, and everyone knows that a citizen that if you do not pay the electricity, it will get disconnected. After the entire wheel has been bought, we gave him a temporary notice. He did not pay even after that. Thereafter, when we issued him the PDC, along with the area, he comes and pays the bill and he says, now you reconnect me. My lord, once the permanent disconnection has happened,
it's a new connection.
Which does not appear. And my lord, in fact, the Supreme Court has gone on to decide with this effect, and this has been reflected even in the order of the Colonel Single Judge, my lord.
Yes. Read which judgment you are talking.
My lord, 108 is the running page number, my lord. That does it appears from the document produced by the petitioner, the electricity supply was disconnected to his premises on 23/2020. Hence, as per the document produced by the petitioner, the permanent disconnection was done on 14/3/2020 was far beyond 180 as prescribed by regulation. In this regard, we may refer to the observations made by the Supreme Court in case of Prem Kotak, which is reproduced here below. In Rahmatullah Khan, this is Ajmer Nigam, Vidyut Nigam versus Rahmatullah Khan, which is discussed below. The three issues arose for the consideration of the court. That they were whether the meaning to be ascribed to the term first due in section 56(2) in the case of a wrong bill of tariff have been applied on the account of a mistake, when would the amount become first due, and whether the recourse of connection may be taken by the licensee after the lapse of 2 years. Then the paragraph 3. But a careful reading of 56(2) would show that a bar contained therein not with respect to disconnection of supply, but also into recovery. If subsection 2 is discussed in two parts, it will read as follows. No sum due from any customer under this section shall be recoverable after a period of 2 years from the date when the sum first became due. But our recoverable was not there, it was there along with the time period itself. The licensee shall not cut off the power of the supply of the electricity. Therefore, the bar actually operates on two distinct rights of the licensee, namely the right to recover and right to disconnect. The bar with reference to the enforcement of the right to disconnect is actually an exception to the law of limitation. Under the law of limitation, what is extinguished is the remedy and not the right. To be precise, what is extinguished by the law of the limitation is hereby through a court of law and not a remedy law. If any deholds the court of law, however, section 56(2) bars merely the normal remedy of recovery, but also bar the remedy of disconnection. This is along with the 56(2). His case is under 56(1). The Supreme Court has distinguished what is 56(1) and what is 56(2). Thereafter, my lord, in Rahmatullah Khan, the court has gone that whether what was due and what was not due. 56(2), however, does not preclude the licensing company from raising a supplementary demand after the expiry of limitation period of 2 years. It is only restricts the licensee to disconnect the asset due to non-payment of dues after the period of limitation of 2 years has expired. Nor does it restrict other modes of recovery which may be initiated by licensed company for recovery of supplementary demand. Then, by discussing all this case, at paragraph 20 of the learned single judge has given the interpretation of how the electricity bill. It appears that respect of payment of energy bill, there are three aspects. Firstly, if the energy is paid before the due date of the current electricity energy bill, the supply of electricity energy would be maintained or continued without interpretation. Secondly, if the electricity energy bill is not paid with due date, the respondent has the right to temporarily disconnect electricity supply. Thirdly, if the permanent of energy charges is made after the electricity energy supply is permanently disconnected, there can be no question of reconnection even after the payment is made, and the consumer would have to apply for fresh connection. This is as per the code and as per the Indian Electricity Act. The question was arose that did we contemplate the section 56? That was even in the first when the notice was issued and interim order was given to him that you have the liberty to apply, the fresh did not apply. Whether we have given the notice of 56(1) also described. That, my lord, as learned single judge, yes, it was properly done. The procedure has not been wrong with us. So, my lord, where did we legally have been wrong? So, my lord, we have told him, my lord, that you apply for fresh connection, we will give you the fresh connection. But he's only harping that he needs the old connection.
My lord, no order is required for applying fresh connection, my lord, for fresh connection. The rule, the judgment which you have read just now is not at all related in the present case because that is for 56(2). We are on 56(1). And not only that, their own regulation. Regulation, my lord, regulation in their regulation itself. They have stated that once the payment is paid, they have to reconnect within 24 hours, my lord. Their own regulation says so, my lord. Your lordship may kindly see, my lord, regulation 8.2.3, reconnection, restoration of power supply. I have reproduced it, my lord, in my appeal, my lord.
This relates to
Temporary connection, not the permanent
No,
disconnection.
it doesn't say, my lord. It says only disconnection. Doesn't say temporary or permanent. It says only disconnection. And Electricity Act 56 doesn't have temporary or permanent disconnection. It only says disconnection. This also says only reconnection, my lord. Doesn't say permanent or temporary, my lord. Your lordship may kindly see page 21. I have reproduced the relevant portion. Page 21, my
Will
lord.
you read 8.3?
Yes, my lord. 8.3.
There is a distinction provided in the chapter itself. The chapter is in two parts.
Yes.
Chapter 8 is in
Yes.
two parts. Till 8.2, it is dealing with temporary disconnection,
Yes,
and
my lord.
8.3 comes permanent disconnection.
Yes, my lord.
So there is no provision in this regulation that after permanent
But my lord,
disconnection,
8.2.3
that is,
doesn't say temporary or permanent.
Mr. Sahu.
8.2.3 may kindly receive, my lord.
that is contained in the part of the chapter which deals with temporary disconnections. The permanent
but-
disconnection is under 8.3.
It doesn't say anything regarding permanent or
We
temporary.
understand, we
It doesn't say temporary also,
We understand that. All right.
my lord.
We'll deal with that argument.
My lord, and my lord, their own, my lord, it was mandatory that they should intimate within 24 hours. They have intimated after 15 months. And then after permanent disconnection, they have to intimate, which they have never done. They have neither come up with the affidavit, their affidavit that whether they have issued format 20. They have never done it. They did not issue notice, they did not issue, my lord, this notice containing in the bill.
For that reason only we are admitting your appeal. We'll consider these academic issues when the appeal is heard.
My lord, the intent prayer can be, my lord.
We'll decide it. We'll decide the intent prayer.
My lord, date can be fixed, my lord. In July.
It will come up for hearing, sir, whenever it is as per its priority.
My lord, let it be in early, my lord, early date.
So it will come up on its own priority.
My lord,
Next case, please.
have to come from.
Item number 8.
You can argue through VC, sir.
Please, Your Lord. You on similar issue, my lord?
Old pension scheme.
My lord, my lord.
Admit issue notice. Respondents are duly represented, thus process need not be issued. Connect and list with so and so.
9 is same.
9 is same.
Obvious.
Item number 12.
Item number 12, they are supposed to file the affidavit, my lord, the education department.
Affidavit, madam,
We have sent it for waiting, my lord.
and counsel MS.
After maybe come after vacation, then an interim maybe continue.
Yes. Praise for and is granted. For the last opportunity of 4 weeks, file the affidavit on behalf of the department. Interim order passed earlier shall continue. List up 4 weeks.
Item number 13.
May I please, I am appearing on behalf of respondent number 6, my lord.
You are putting in appearance?
Yes, my lord. I may kindly be allowed some time to file the reply.
Were you not there in the proceedings?
My lord, yes, I am there.
So didn't you file your affidavit in
Yeah,
the
this reply, my lord. Kindly allow to file.
and counsel for the Miss so and so has put in appearance on behalf of the respondent number 6?
Yes.
He prays that he may be allowed to file an affidavit on behalf of such respondent in this writ appeal. 4 weeks time is granted for the filing affidavit on behalf of such respondent. List of 4 weeks.
Item number 14.
That is fixed by the circular officer on 28/6/2023 lordship. Yeah, before that, no date was fixed, so the district education was not provided the assistance lordship. Kindly please find
What are you saying?
lordship on 28/6/2023, that is fixed by the circular officer
For what purpose?
for possession.
Why this matter is taking so long? Why it is being prolonged? Can you tell us?
That has been mentioned here, lordship. Circular officer was transferred, lordship. He has not fixing any dead, lordship. That is why.
So we are directing your deputy commissioner to ensure and the superintendent police to ensure that possession should be provided on 28th. Otherwise, we'll keep officers present in the court on each and every date.
28/6.
So this should be done on that day. Then Council MS Bora submits that 28 June has been fixed as the date for providing possession of the mortgage land to the petitioner here. She assures that requisite compliance shall be made on that day. We make it clear that in case possession of the land in question is not provided to the petitioner on 28 by 28/6, this court shall be constrained to direct personal presence of the superintendent police Sivsagar and the deputy commissioner Sivsagar in these proceedings. List on 20th July for receiving the compliance report. Much obliged. Copy of this order shall be communicated to the Deputy Commissioner Sivsagar and the SP Sivsagar through email.
Item number 16.
Where is Mr. Chaudhary?
On the last occasion, my lord.
Yes, we had given him that
Yes.
to find out what is the status. Password, call Mr. R.K.D. Chaudhary.
Yes.
Item number 7 to 19, 17 to 19.
May please, your lordships.
Mm.
My lord, these three appeals are against the common judgment. May I implore your lordship to kindly take up item number 18, my lord, that is completing.
18 then.
our- My lord, there was my lord, the contract for construction of roads under the Prime Minister Gramin Sadak Yojana.
PMGSY, yes.
There were, my lord, as many as 342 packages. And the petitioner, the read petitioner, my lord, was granted, my lord, 3 contracts which we are concerned with. Now, there was a my lord, notification of this government, gazette notification of the state government that provided that if the offered price is within 10%, beyond 10% variation of the estimated cost, then that is a disqualification criteria. And all the my lord contractors, my lord, who were working with the PWD, they were aware of it, and they were according, my lord, the present appellant also filed within that, my lord, price. Now the read petitioner, his bid was, my lord, below 10%. And my lord, what happened when it was granted? Although my lord, the petition was L1 because it was below 10%, and the my lord contracts were granted to us. Then my lord, the notification, a communication came from the government that my lord, this from the my lord center, that this 10% variation, beyond 10% variation is contrary, my lord, not in conformity with the PMG SPI guidelines. And accordingly, my lord, there was a direction that all these contracts which were, my lord, given beyond this 10%, that should be cancelled, and my lord, fresh
tender should.
tender should be given. But the honorable single judge, my lord, has in fact allowed those petitioners to, my lord, have that contract without, my lord, conforming to that part which says that it has to be fresh. In fact, my lord, we were given the contract and we had completed certain parts of the contract. And there was a direction in the read petition that that part would be calculated. But what happened, my lord, in the meantime, that should be calculated, and there was a particular clause in the, my lord, the earlier guidelines. According to that, my lord, the assessment has to be made, and that has to be given. And our the work that we have done, that
Pro rata basis, the work, the pro rata
yes,
basis,
my lord, but
the payment would be made.
Yes, my lord. But what happened, my lord? The work stopped in between. And because of the flood, my lord, everything we did, about 30% of the work that was, my lord, washed away by the flood. As a result, my lord, the entire contract now goes to the read petition. Now, my lord, what I am, my lord, trying to project before your lordship is that, firstly, 2018 notification is, my lord, followed by all the contractors, except, my lord, this read petitioners. And we all knew about it, and accordingly we did it. But my lord, after the communication from the center that it is not in accordance with the PMG SY guideline, so it ought to have been cancelled and fresh.
Tender.
Then, my lord, we could have competed because we did not go beyond 10%. That is one submission. And secondly, my lord, the stand that has been taken, my lord, the part of that, my lord, communication has been set aside by the honorable single judge, saying that the petitioners should be given the contract subject to fulfillment of this. Then another point that arises is that, my lord, I have filed an additional affidavit that there is a, my lord, question of the bid capacity. Now, the read petitioner made some false statement that he had no existing work going on. But in the read petition also, in the affidavit also, we had taken that ground. And, my lord, now there are 2 ongoing projects that was already there, and
That was the status when he filed his bid. At
Yes.
that point of time, whether he was compliant or not, that is to be seen.
That is one question. The other question is now, my lord, after the presently, my lord, I have instructed all the works have been given to him. Now that they do not, he does not want to fulfill that requirement. On that, my lord, an additional affidavit is filed, if your lordship kindly
Fulfill
takes
what
a-
requirement?
Hmm?
He doesn't fulfill what requirement?
Bid capacity.
Bid capacity.
My
So
lord.
technical criterion he
Yes,
doesn't
my lord.
fulfill.
He doesn't fulfill now, my lord. Now,
Now means what?
out of this,
That requirement of fulfilling
my lord.
would be relevant on the date the bid was evaluated.
My
On
lord,
that
when-
day, if he was compliant, he's compliant.
That was, my lord, that may be compliant, but then, my lord, there was a, my lord, the wrong submission made. My lord, in the bid, my lord, he had shown that he had no work pending,
Hmm.
which is not true. That also from the affidavit of the, my lord, government. That is one, my lord, and because of this false statement that his contract is liable to be cancelled.
Where
Now,
was
my
this,
lord, after
where was
this-
this argument made
My lord,
before single bench, whether his argument
Yes.
was made?
yes, my lord.
Let us see.
Your lordship will find that in the judgment. What is that? Now what happens, my lord, after all these contracts are given, his bid capacity is, my lord, now about 12 crores. Whereas, my lord, the bid capacity that is required is more than 14 crores. That I have shown in the, my lord, additional affidavit. On that, my lord, I'd like to have request that, my lord, your lordship will get the instruction from the PWD. Because, my lord, if that is so, my lord, he cannot get all the
Yes,
contracts.
that's right. Yes, Mr. Gogoi.
My lord, here, so far as this issue is concerned regarding the bid capacity.
First, we would like to satisfy where this issue was raised before single bench.
No, my lord, this could not have been raised. Because,
Why?
my lord, I am an individual.
Uh-huh.
So on individual basis, my lord, he fulfills the capacity.
Uh-huh.
Now he has been given five
Five
contracts.
works.
Now, my lord,
Whether
he-
you have taken this ground in appeal.
in the appeal, we have, my lord, in the appeal, we have taken the ground.
Let
And,
us
my
see.
lord, in the additional affidavit, we have, my lord,
All right,
submitted the
Mr.
document.
Gogoi, you respond to the additional affidavit. And the private respondent will also have to be restored. File his response. Or the senior counsel has drawn the court's attention to the contents of the additional affidavit filed on behalf of the appellant containing certain subsequent developments which are projected to intend that the respondent having been provided 5 contracts, is not having the capacity to carry out the works in question. And would be technically disqualified. Then counsel, Mr. Gogoi representing the PWD and then counsel representing the private respondent pray for and are granted. Is that how much time? 4 weeks time
Yes, my lord, 4 weeks.
to file an affidavit in opposition
I pray for a
to counter this aspersion made on behalf of the appellants. This is there in all appeals.
Yes, my lord.
Yes, my lord.
All right.
Free appeal.
My lord,
List.
may I pray for a fixed date, my lord?
Definitely. Why not? 21st July.
My lord.
How like?
Supplementary list, item 39.
May I please, lord? My lord, I have prepared a short compilation of the matter. So I have given the copies. Lordships may kindly look into this. My lord, this is perhaps a unprecedented case I am submitting. My lord, the Kajalgaon Municipal Board, Lordship is aware that is the local self-government. In the year 2013, my lord, Kajalgaon Town Committee was constituted by the government of Assam, 2013.
And in the year 2018, that was upgraded to municipality. So when the town committee was constituted in the year 2013, since then, that committee has been allotting different hard ghats, bazaars, etc. within its area to different person by inviting tenders. And the private respondent number 6 here, my lord, they say that in the year 2017, we have got a plot of land mutated in our names. Now, Lordship, my lord, if they have got the land in the year 2017, but till the year 2022, we are allotting the bazaar to the lessee by inviting tenders. Till 2002, I have given all that, Lordship may kindly see 3.3 of my compilation. So from 2015-16, then 16-17, 17-18, next page, my lord, 2022-23. So till the year 2022-23, we are settling the Kazalgaon weekly bazaar in favor of various persons by inviting tenders. All the orders and the allotment orders to the lessees have been already annexed in this writ appealment. Now, the private respondent number 6 filed a writ petition. But considering their motto, we lost 2 caveats. One caveat was lost by lessee. That Lordship may kindly see page, my lord, 142, page 142, dated 12/5/2023. My lord. On 12/5/2023, one caveat was lost against respondent number 6 by the lessee. And another was lost by present appellants, that is Kazakh Municipal Board on 23/5/2023. These caveats are in the registry of the Honorable High Court, my lord. But the writ petition and respondent number 6 herein, we don't know how they got past the writ petition without annexing the caveats. And the matter came to the learned single judge. Learned single judge on 5/6/2023 passed order that the settlement order of the Kazalgaon weekly market shall remain state until the next date. Now we came to know about this. Then we filed a petition before the learned single judge.
Yes. Where is
That, my lord, there was a caveat that was lost on 12/5 and 23/5. Order was passed on 5/6/23. First time, my lord, when the 5/6 order was passed, there is nothing to say because caveat was not there. But we filed review petition that Lordship may review the order because that was passed by passing the 2 caveats. Even then, learned single judge did not stay the order nor asked the parties to serve the copy of the writ petition which was filed by respondent number 6. Now, my lord, those are the avenues collected by the municipal board for the Lordship is aware this is the source of their finance. Different orders of the Honorable High Court. I have also mentioned in my writ petition that Lordship may kindly see page
Issue is, Mr. Mahmood, Mr. Counsel.
15 to 16.
You settle the market at a different position.
My
The
lord.
location, change the location. Why you are so obsessed with that plot? That the petitioner claims that the plot is mutated in its name.
Yes.
Is the owner of the plot. He doesn't want you to do business on the plot.
No, already we have wrote to the government,
Yes,
BTC government, that it has been done fraudulently without our knowledge.
that is a different thing.
So we have wrote
But
the
there
letter.
is a mutation as on date.
Yes, there
So
are.
it has a right to say, no, that is interference in my civil rights. You can't interfere. What is wrong in that? On merits, if you come, what is wrong in the claim of the
No.
petitioner?
Thing is, merit, we also want that learned single judge should have passed the order on merit.
That we
But thing
understand.
is, we got no chance.
We understand, Mr. Chaudhary. But now we are asking you on merits.
Yeah.
What right do you have to encroach upon the private property? For
No,
holding
that is not the, because, my lord, they say that is done in 2022 or later on. Because it was, if it was obtained in 2017,
Then till the year two thousand
All
twenty-two.
right, that was ignorance on their part. Or say it is an indulgence provided to you, all right, keep on doing it.
No, that.
They have a right to wake up and say,
Because they never raised any question.
does that give you a right that you can continue to act in that manner
My lord.
for years together without consent of the two
My
owners? of the
lord,
land?
let me satisfy your lordship. The municipal law says the municipality has a particular area as per gazette notification. Within that area, excepting the private patta lands, other lands belong to municipalities. They will lease it. So these are the powers of the municipal board.
Get that.
So my
issue
lord,
settled.
my only simple prayer is this, man. I am not awaiting to a fast on merits. But thing is, this order of 5/6/2023
Yes.
was passed behind our back without serving notice, though there is caveat. Whereas the Honorable High Court, various High Court, Guwahati High Court, I have
We understand that.
given
We
the
understand.
judgments.
Let us see how your miscellaneous application has been dealt with.
So that is a nullity. That order is a nullity in the eye of law. If the caveats are bypassed and concealed, that is the order of nullity, my lord. I have given so many judgments of our High Court, Himachal Pradesh High Court, Allahabad High Court, Karnataka High Court. So my submission is this, my lord. If the municipality is not allowed, a part by part is taken by everybody, how the municipal board will run? Then how the municipal like 1956 would come into force? So we have the complete control over the property of the municipal area. This is the settled position of law. Now somehow they got it, but till the year 2026 they will remain totally silent. All uncertainties has come, I don't
Who is
know.
appearing for the respondents?
So 5/6 order may be statement. That is my only prayer. And let the matter
Who
be
is
heard.
appearing for the private respondent?
Private respondent.
The notice has to go then.
Notice, well, they have not got any caveat, my lord.
No, but notice will go then.
Notice may go, but till then, my lord, some,
Without hearing them, no, sir, sorry.
my lord,
Issue notice to the respondent.
5/6.
We will be committing the same mistake.
No, no, my lord. They have not lost here. We have lost to their gulf of difference.
So we'll decide that issue, no? We are not shying away from deciding.
Now, my lord, that bazaar, there will be some.
What further?
That
You hold
bazaar-
your market somewhere else. What irreparable loss is being caused to you? Tell us.
Because that is a source of our income.
All right, so you do it on a different plot of land. What is the problem then? They have not stopped you from holding the market. The only direction is don't do it on that particular plot. Do it elsewhere.
Then, my lord, there is already a settled market. So many houses are there. Then lordship may kindly observe that Kazalgaon Municipal Board has the right to shift the market if they want.
Can you read the order, please? Please read the order, interim order.
Yes,
What is the order?
155.
Read, please. Do you require any such clarification?
So that, my lord, I am reading, my lord, page 155 bottom, 158 bottom, it may be seen,
Yes.
with 3 lines.
It is therefore provided that till the returnable date,
Yes.
settlement of any market made in favor of respondent number 9 by the respondent municipal board authorities
Yes.
in or over within the subject plot belonging to the petitioner's society shall remain state. So stay is not to do it on that plot. Do it elsewhere.
No, that is there, but some wrong impression of their lordship may kindly observe.
Let us see your tender notice first. What is the tender notice?
But for the timing, my lord, municipality
Just
has the
we-
right.
We would, can you respond whether the petitioner has also filed its bid in the, for the market? Whether the writ petitioner also made a bid for the market? Is it a bidder?
No, so far my instruction is that they have not made market, but some relief, my lord, others is
Just hold on, hold on.
local self government, they should get some priority. If everybody takes the places of the municipal area, how the municipality will run, my lord?
Yes, we understand. We are asking you simple question, whether there is a dispute in the writ petition that the petitioner is also entitled for the market, to bid for the market.
No, they may submit their bid, that there is no bar, but that may be observed, if they are a candidate.
Where is your NIT? Where is your NIT?
NIT, yes. NIT that may be seen. Page 71, my lord.
The Kazalgaon Weekly Chalk Bazaar.
Yes.
Right. The location is not mentioned in this. There is no mentioning of the location.
Kazalgaon Weekly Chalk Bazaar, that is the Sunday market.
We understand, but this NIT doesn't say where the market will be held. See, the petitioner has tried to portray a case that it is the landowner,
Yeah.
holder of the land, and you can't hold the bazaar there. That is the only case of the writ petitioner.
Yes.
Your tender notice doesn't say that you will be holding the art bazaar only at that precise location. Is it correct or not?
There is a questionable argument by that even that logically observed that the municipality has the right to shift the market any place that can be observed. Some really
The issue involved in this intra-court writ appeal filed against the order dated so and so is that the appellant herein, though having filed 2 caveats against the proposed writ proceedings, was not heard by the learned single bench before entertaining the writ petition number so and so and passing the interim order restraining the appellant from organizing a weekly chalk bazaar in the plot of land on which, the writ petitioner claims ownership oblique holding rights. Patta rights. He claims to be the patta holder of the land in question. It is indeed a matter of concern that in spite of the caveat having been filed by the appellant, neither the fact regarding the caveat was indicated when neither the caveat was placed before the learned single bench when the matter was taken up on 5/6/23, nor did the counsel representing the petitioner, provide a copy thereof to the caveator. Be that as it may. On going through the order dated 5/6/23, we find that the primary issue involved in the writ petition pertains to the claim of right over the plot where the bazaar was earlier being organized by the municipal body on annual basis.
Yes. Since the year 2015.
Is it an annual or weekly feature?
Anyway.
On annual basis. Settlement title says Kazalgaon Weekly Chalk Bazaar.
There is the Kazalgaon Weekly Market. That is also called Kazalgaon Weekly Market.
But this NIT you have issued,
Yes.
that market takes place every year or every week?
Every year, once a time in every year. Every week, yeah. Every Sunday the market sits.
Settlement of the NIT was issued for settlement of the weekly market under the title of Kazalgaon Weekly Chalk Bazaar. The learned single judge, by order dated 5/6/23, has directed that the settlement of any market made in favor of the respondent number 9 shall not be permitted in, over, or within the subject plot belonging to the writ petitioner society. Thus, this court is made to understand that the petitioner society has not filed its bids in the N19 dated so and so. Thus, come on. We make it clear that the appellant municipal board shall not be precluded from settling organizing the market at any different location.
Problem.
Issue notice to the respondents.
The state condition is there in the NIT, page 74, clause number.
What is the condition?
17 and 18.
Page 74.
Any part of the hard further may be relocated by changing its existing
Yes,
location.
we are making this observation in light of the condition number
17 and 18.
17 and 18 of the NIT, which provides that any part of the hard bazaar may be relocated by changing its existing location if necessary in the public interest.
By the municipal board.
By the municipal board. Who is the respondent number 9, by the way? Why the respondent number 9 has not come up?
9, my lord, actually, this is our concern because we have to pay salaries to our employees by
You're
the
right,
income. He's a lessee for 1 year, that already, several months have gone already. Obliged, highly obliged.
Item number 40.
6 weeks.
May I plead the lordship? This matter will be taken up after some time.
Just
Lordship,
matter may be taken up.
after some time.
Can it be on Monday, my lord?
No, my lord.
I'll be preoccupied in another court.
Madam, council is saying that argue it right now, or if not, then on Monday.
No, my lord, senior counsel can schedule argue this matter, my lord.
We don't say that he'll not argue the matter, but he has to be here if he wants to argue.
Today,
He is not agreeable to a passover. What to do?
today, sir.
On Monday, my lord.
He has some difficulty. He is engaged elsewhere. Mr. Chaudhary, right now, you say that Mr. Chaudhary is engaged. He is here now. So if his engagement is important, his engagement is also equally important.
Coming, my lord.
I'm sorry, my lord.
Someone was saying that the engagement of senior counsel, Ms. Chaudhary, has to give precedence over engagement of other counsel. Is it a correct statement?
No question is there.
अपनी आगे को
May it please your lordship. My lord, this particular fishery was settled with the appellant, my lord. Now it has been interfered by the learned single judge.
Yes.
Now, my lord, the settling authority did not settle the fishery with the respondent with petitioner society on 2 accounts, my lord. First, that the certificate of they being the 100% actual fishermen, it was given by an authority other than the authority prescribed in the tender and in that 18/1/18 notification. And secondly, my lord, prior to this, my lord, this decision-making process leading to this settlement, there was a litigation before this honorable.
You were respondent number
10.
10 in the writ petition.
Yes, ma'am.
Were
No,
you not
respondent number
represented?
10 is the writ petitioner.
No, but you were the respondents in the writ petition.
Yes.
Were you
Our
not
settlement-
represented?
Our settlement has been set aside by the.
Were you not represented?
My lord?
Were you not represented in the writ petition?
Yes.
The attendance is only of Mr. D.K. Sharma.
Oh,
You don't know.
no, we appeared, my lord. In fact,
We don't know.
our
The
counsel's name is also
Judgment
recorded.
doesn't reflect.
Oh, yes, yes, yes. Oh, yeah.
26.
Anyhow,
Correct. ma'am. Then, my lord, the settlement was interfered by the learned single judge on the ground that the settling authority took note of irrelevant consideration. Now, my lord, the basic cases of the neighborhood. Now, let me explain one thing, my lord. This fishery rule has a background. My lord, before the earlier amendment, my lord, there was a power of direct settlement with the government, provided they fulfill 2-3 conditions. Now, subsequently, my lord, it so happened, the many societies have come up in respect of the same area of operation. Then, my lord, the government amended the rules where they said even 60% fisheries will be 60% category fishery will be settled by tender system. But cooperative societies, NGOs, and self-help groups. But neighborhood is nevertheless, my lord, a very important requirement. And my lord, these are all statutory contracts. It can't be construed to be a commercial transaction in this sense, where my lord, this full bench of this honorable court has already said that as long as the scheduled caste population of the people living in the neighborhood of the particular fishery is gainfully employed, government is even prepared to lose the revenue. That is the basic objective, my lord. Now, having regard to that objective, if your lordship will kindly come to page 34, the very statement of the writ petitioner in the writ petition, my lord, page 34. Para 5. Petitioner begs to state that at present there are total 114 number of members of the petitioner Samavai Committee residing with the operational area of the petitioner Samavai Committee, who belongs to 100% actual fishermen community, having its office at so and so, so and so, so and so. To that effect, Assistant Registrar of Cooperative Society, Khanapara Guwahati has issued a certificate stating inter alia that Society of the Petitioner is a registered fishery cooperative society and composed of 100% actual fishermen belonging to Koiboto so and so community, which is a recognized scheduled caste under the constitution of SC. In the state of Assam, all petitioners are actual fishermen. There is no averment that the members of the petitioner society reside in neighborhood of this particular fishery, which is a prerequisite, my lord. Now, please come to page 65, their certificate, which they are referring to. Kindly come to the second subpara. The society deserves settlement as all the members of the society are catching fish. In this connection, preference may be given as practicable to reorganized fishery cooperative society located in the neighborhood of fishery number 25, Depusijan and Molia group of fishery. Now, what is the fishery in question, my lord? It is Kamrup, Pragjudishpur, Brahmaputra, mean Mohol. So, my lord, there must be a specific averment when you are seeking benefit under Rule 12 that you belong to this particular area and you are in the neighborhood of this particular fishery. On one end, there is no statement. And secondly, my lord, they, by their own showing, they are in the neighborhood of fishery Mohol called Depusijan, Molia group fishery. Now, my lord, Lanet Single Judge records a finding that the finding of the authority is bad. Earlier, my lord, there was a direction by this honorable court to find out the status of
About the status.
Yes.
That
Now
was an
that
ex
has
parte
been
order.
settled. That has been settled, my lord.
That was an ex parte order.
Yes, my lord.
That was an ex parte order.
No, my lord. But even then, my lord will kindly see that is not under challenge also. Page
The
88.
review was filed.
My lord.
Review was filed. Seems the briefing is not proper, Mr. Chaudhary.
No, my lord will kindly come to page 70 for a moment, my lord.
Yes.
Sorry, page 88. Page 88, this is the order which was passed, my lord, in case of the writ petitioner. I'll have your lordship's kind attention to the last two lines. Neighborhood certificate submitted by number column so and so, that is the writ petitioner society. In their tender paper being numbered was examined and the information.
You challenge the tender in anticipation.
No, my lord. No, we challenge their certificate, neighborhood.
So
certificate.
their attempt to file a
Yes, yes.
in anticipation.
Provided through the certificate is incorrect, as none of the operational area of the society is situated on the bank of Kamrup, Brahmaputra fishery jurisdiction. Majority of the society of the shareholders reside in Govardhan village, which is situated in the bank of Kolong, another fishery, my lord. So if they're not in the neighborhood of the fishery,
How was this?
now,
order
my lord will kindly have
considered?
this fishery rule for a moment.
How was this order considered?
Yes.
Let's see.
Now, my lord, I'll just refer to 2 pages, my lord. Please come to page 153. Para 30. the rejection of the bid of the petitioners while impugn order dated 18/11/19 is basically on two grounds. Namely, 100% actual fisherman certificate was not issued by appropriate authority, that is ARCS concerned. And secondly, ground of neighborhood, with the finding that majority of the shareholders of the petitioner society reside at village Govardhan, which is situated at 1 kilometer distance from the fishery. As far as first ground is concerned, the same appears to be perverse ground, inasmuch as such certificate issued by ARCS has not only been annexed to the writ petition, but is also there is a fair disclosure by the London State Council that original record indeed contains such a certificate. And an attempt has been made by Sri
Para
Bhattacharya.
31, please.
My lord.
Para 31,
Yes,
neighborhood.
yes. As regards the second ground, neighborhood, the finding arrived by the impugn order is that majority of the shareholders of the petitioner society reside at Govardhan, which is seated. That is not the only thing. That they're also, my lord, in the neighborhood of Polong Fishery. That is most important, which is not mentioned. The list of members along with their address would show that other than the village so-and-so, there are other villages also where members of the petitioner society can reside. The mere fact that certain members are residing at a distance of 1 kilometer cannot be governed the fate of the fishery society. My lord, with all respect, I'll submit, my lord. In case the two society are in the same area of operation, then this distance aspect will come, my lord. There, my lord, merely because somebody is more nearer, one cannot have a better claim. But this is not the case. Here the case is there in the neighborhood of another fishery. It is their own certificate. My lord, where is the scope on that ground to interfere, my lord? With all respect, I'll submit. Base certificate clearly indicates that they are in the neighborhood of deposits and fishery, my lord. Or Polong.
Leonard Single Judge has referred to Brahmaputra Part 2, the
No,
judgment.
these are cases where, my lord, the situation was in the same area of operation, there are two or more.
Let us see the judgment then.
Oh, judgment.
Let us see the judgment.
Sorry, my lord, I get it.
This is the very foundation
Yes,
of giving this interpretation.
my lord, I'm very sorry. Can it be taken up tomorrow, my lord?
Tomorrow not possible, sir. It will come up on Monday.
Apart from that, my lord, I like to apprise one thing, my lord. My
Yes.
learned senior counsel has skipped the vital document, which is the neighborhood that your lordship will see at page 50 and 52.
What is the document?
That is, my lord, para 4 I have written in my writ petition, my lord. It is about my fisheries neighborhood certificate issued by my lord circle officer. Another issued by also circle officer about my status about my neighborhood certificate.
My lord,
Come on
my
Monday,
learned
come on
senior
Monday.
My lord, can I make one submission, my lord? In the meanwhile, my lord, my settlement has been interfered with. Another settlement order in their favor has been issued. My lord, till Monday, it will not be
No, my
acted
lord,
upon.
why they will give, my
No,
lord?
no, otherwise,
I
my
am,
lord,
lord,
nothing
difference
survives.
of 22 lakhs, my lord. He offered price 38. I offered price 60 lakhs. On the wrong conception, my lord, my case, no interim can be granted, my lord.
My lord,
I am
This is
the
an opposition,
caveator, my lord.
Mr. Chaudhary. This is serious opposition.
no, my
My
lord,
lord, that cannot be
let the
given, my
status quo be there
No,
till
my lord,
Monday, my
cannot
lord.
be, my lord. Otherwise, my
Or
lord.
else, lordship
Who
will
is
take it.
there for the fisheries department?
My lord will do, my lord. Government has issued a order, my lord.
When?
Yes, yes, I
What
got
is
a
the date
copy,
of the
my
order?
Haji, na?
lord. It is already.
What is the date of
Yesterday,
the-
my lord, we got
Yes.
the order.
Let
But they
them
will not
challenge
give
that
effect to this order till Monday.
Why, my lord? It is still Monday, my lord. They have
What
running
difference
to-
would it make?
It has been
There are-
cancelled
Monday.
already.
The quantity of fish will be reduced.
No, no.
Yes, yes, they will reduce, my lord.
Let them do, let them
No,
enjoy
but
for 3
otherwise, he
days.
will take over, then lot of
Look,
complications will come. My lord.
What complication?
My lord, they will take over, then my lord,
They'll
otherwise
use
also,
their
my-
own,
no, only
own
thing is, my lord,
vessels.
not today, the Monday they will enter, if your lordship is not satisfied.
Chaudhary, we gave one chance, waited for you. Now you are not prepared. What can be done?
No, my lord, the judgment I didn't brought
So that
because,
the entire foundation of the reasoning is that
True.
judgment, sir.
so that's why, my lord, I
So
started my argument.
come on Monday, we are not passing any effective order. We're just deferring it on your request.
Yes.
So that let it come out.
Or can it be taken up at 2 o'clock, my lord? I'll bring the judgment.
Monday.
2 o'clock I can.
He has earlier also requested that it will not be possible to come in the second round. That is why we were making that observation.
Oh,
The
I'm sorry.
priority of Mr. Chaudhary can't be more than the priority of other council.
Last year.
Certainly, certainly.
Last year.
Yes.
How less?
Item number 41.
May it please your lordship.
Yes.
My lord, your lordship may recall, this is one writ petition which was filed by an assistant professor of the oncology department of the State Cancer Institute of Guwahati Medical College. Now she has, through a regular process of advertisement and selection, she has been selected as an assistant professor E of Bibora Cancer Institute in the same city, which is around a distance of 4 kilometers. Now, my lord, the government, we have seen the affidavit filed by the affidavit in opposition filed by the government. The government quotes a letter of 11/3/2022, in which they say that there was a meeting of the chief minister and along all the stakeholders, and they say that in the your lordship will find that letter at page 58 of the affidavit in opposition filed by the respondent number 3, my lord.
Yes.
It's a running page nowadays, it's page 58.
Yes.
If your lordship will look, your lordship will find that the department is radiology. Now, so far I am working at the present department is, it is, my lord, radiation oncology cancer of state. There's a lot of difference between radiology and radiology. Now the government says that so far this FSM, anesthesiology, dermatology, radiology, they say that they are dirt of professionals.
Oncology and radiology simply, there is a huge difference.
Huge difference.
The
Now
area
your
of
lordship
operation
will
is entirely different.
Now your lordship will see page 60 of that affidavit. Now, page 60 of the affidavit, your lordship will find Department of Radiation Oncology in the medical colleges of Assam. Page 60. Now, your lordship will find at the second GMCS for GMCS Guwahati, your lordship will find that there is only one assistant professor, one which is filled up. And they don't have any department as such in the GMC.
Oncology, there is no department.
But there's no persons, no functioning. So even that professor works in the next, that is State Cancer Institute, GMC Guwahati. Now your lordship will find that associate professor is vacant. Why? Because experienced persons are not there. Because to become an associate
You have been selected in which institution?
In the Bibora Cancer Institute, which is a specialized institute.
Okay.
Now your lordship will find that assistant professor 3 fill up. So if I go, there will already be 2 professors and one which is already there in GMC, which is also there will be 3. The other 2 professors can't go to Bibora because they are not selected. So at the moment, they will already also have 3 professors there. Now your lordship will see.
Your client is on which post?
My lord, I am now an assistant professor.
Assistant professor. So you are presently working in GMCH.
GMCH.
So that one post filled up.
SCI.
So one
in the same campus only.
Yeah, we understand. So one post which is filled up is only by your client. Assistant professor number 3.
No.
Fill up 3.
Yes, assistant professor 3 is the total number of posts.
Total number of posts. Okay. So
3 persons are working.
All 3 are working.
Yes. If I go, 2 will remain.
2 will remain.
And the one which they are showing in GMCS, he is also working there. So at present, there will be 4.
Sufficient
if I go,
numbers.
then 3.
Yes.
Now I have been appointed, my lord, in GMCS. Your lordship will find my appointment letter at page 41 of the writ petition.
41.
41 is my appointment letter, assistant professor E radiation oncology, and your lordship will find. So far I am concerned, my lord, I am a alumni of Bibora Cancer Institute. I have to sign a bond to serve the 1 year. That 1 year I had served, and after that there was no post. That's why I came to GMCS. And now, so far this your lordship will find this post E carries with a higher grade like DE, and it's a incentive to get more salary and all. They have a grading system in Bibora Cancer Institute.
Have you said so that this is a post getting better incentive?
Yes, madam. We have said that why we are going to that is there. That we will not miss those on the pleadings. It is there in paragraph number 2 of the additional affidavit. Your lordship has actually pointed out, and they are concerned. They say quote a rule, my lord, at page 50.
50,
my lord, clause 11. The acceptance of the no objection certificate for applying to any post, be it directly under central government or any state government or any other organization authority established by the central or state government or any other organization, shall be considered only if patient care. Patient care will not be affected because 3s are already there, or academic services at such institute college, that will also not be affected. 3 are there. Where a member of service is so serving are not affected and shall be dependent upon the need of the larger public interest. This larger public interest, they have not specified how it will be affected. It's a too wide a concept. And I'm not going out from the state. I'm going from one institute to the Cancer Institute, which is a more specialized institute.
And that is also a government-run institute.
Yes, it's a collaboration with the Tata Memorial Cancer Institute. Earlier, people from Assam used to go in Tata Mumbai, even when I took my grandmother in 1992. Today, my junior assistant counsel, her mother is being taken to there to treatment because that's a better
That is good that yes, the state is gearing up for the latest medical facilities. That is wonderful.
And your lordship will see again at page 60, your lordship will find at page 60, your lordship will find that they are stating about this Cancer Institute in all the medical colleges in Assam. But your lordship will find that all the posts are vacant in those institutions, except as this SCI GMC Guwahati and AMC as Dibrugarh. All other there is no Cancer Institute functioning in any of those medical colleges.
There's one in Lakhimpur also.
Lakhimpur,
Professor.
Professor. All vacant, my lord, except one professor is one there.
Professor is there. Professor.
Yes. So there. So I'm not going out from this. I can cite those judgment of the Rajasthan High Court, Odisha, Rajasthan High Court.
Any judgment of Guwahati High Court, please.
Guwahati High Court. What has happened during the interim?
Rajasthan High Court just has a persuasive value. No precedential value.
Even Odisha. In Guwahati, what has happened when AIMS opened up? Some of the professors applied for AIMS. Then NOC said that you can apply. We will decide your NOC. But luckily for the state, those candidates did not got selected in AIMS.
Okay.
So that way, that matter did not reach the final stage.
Okay.
The Rajasthan High Court today. It will the photo conde. And Odisha High Court.
Yes.
So basically, the ratio of the judgment are that if you get a better prospects and all, you should not stop the people to go for their. On a lighter vein, my lord, it's telling with your lordship.
So you are citing a single bench judgment.
Yes, my lord. But only for persuasive.
Rajasthan High Court in Guwahati High Court.
But persuasive bill only. Odisha High Court.
Not even persuasive value.
Odisha High Court is also a single bench.
Again, single bench judgments.
On a lighter
So
vein.
why have you come to division bench?
Because the rule is under challenge, so they learn a single judge because refused to take up.
What rule?
That rule 50, that page 50, which I.
What is wrong in that rule?
My lord, so far this rule is concerned, my lord, this rule is arbitrary in the sense that when you talk about the larger public interest, it's too wide.
That in medical facilities, in medical provisions, these larger public interest has to be there. That will be the primary requirement. So rule, so far as we are concerned, is hardly any.
Because they have quoted this rule only as an abandoned question, because otherwise our petition may be dismissed that you have not challenged the rule. That's why you have to go. That's why we take it as an abandoned caution to challenge the rule, and that's why the matter has been before the division bench, and the pleadings all are complete, my lord. Even
yes, Mr. Saikia, there is a logical argument that our prospects are brightened. Why? And you have ample number. If you did not have ample number of people, we would never have interfered. But therein, the situation is that there are enough people. And that is a better institute. So if you fortify that institute by good people, it's not that she is leaving a government facility. She is going back into the government facility only. That is also.
That is not state government, lordship. That is central government institute.
In any event,
that is number.
That is in Guwahati.
And this institute, Cancer Institute at Guwahati Medical College, it has the highest footfall. Much more.
That we don't know.
That number of vacancies.
Number of vacancies is not there. That's what it is persuading us to even have a look at the money. Let's see the chart again.
Yes, the third page 60.
60.
Lordship will kindly see GMCH Guwahati. We are not on that. Radiation oncology, SCI, that is State Cancer Institute, GMC.
Just have a look. Professor filled up. We are concerned with SCI. No?
Yes,
the professor is vacant.
Vacant.
So she is not a professor.
Professor 2 vacant.
Sakya, she is not a professor. professor. She's an
Yes.
assistant professor.
Yes, she
And
is
you have got
assistant
three.
professor. She is, what is her qualification? Lordship will kindly see her qualification.
Hmm.
She is absolutely required here because she is the only person, page 6.
6.
Yes. Paragraph 2.
Hmm.
The petitioner after passing MBBS from Guwahati Medical College, this is where the Cancer Institute is there.
Hmm.
And MD radiotherapy, radiation oncology.
Hmm.
So that is why
From B. Barua Cancer Institute.
from B. Bora
That is
Cancer
her alma
Institute,
mater.
she wants to go back there, but
Yes.
she done her MBBS in our college. That is,
That's all right.
that is not the issue.
That's
The issue is that radiation oncology, she is the only person.
No. Read 63. This is the entire list of radiation oncology.
Yes, Lord.
The entire list talks of experts in radiation oncology. Read the top heading,
Regarding,
Department of Radiation Oncology. So there are 3 assistant professors already in SCI.
that is what the type copy is at page 60, Lordship.
Hmm.
So here we need total number of 1.
You already have 3, Mr. Saikia, and
We-
she is one of them. 3 and 2 are associate professors.
Who
The
are
asso-
associate.
yes, They are vacant.
No, associate
Associate professor
professors
is vacant.
vacant and professors vacant.
Hmm.
We have 3 assistant professors
Hmm.
filled up and registered 2.
Hmm.
These 5 persons are not sufficient, Lordship. And
Hmm.
her special role as a radiation person, Lordship.
No, but these are all experts in the same field, radiation oncology.
No,
There's no difference. Yes, the heading says so. Department of Radiation Oncology.
Lordship, the thing is that her service is, otherwise we have no difficulty in releasing her.
That's right. There cannot be any hesitation on that.
Yes, Lord.
But what about, she says that her prospects are brightened.
That counter we have, because we have that special progression scheme. At paragraph 9
Progression
of,
scheme will come in late.
yes, the government
Right
of
now she
Assam
gets-
has implemented dynamic assured career progression.
That is all right.
Scheme to the
MSCPS,
doctors, only doctors we are giving.
that comes into picture after 10 years of service.
Immediately she is going to get the next higher level promotion also. That is also due.
Have you made a statement? Lure her with some kind of,
No, we do not want to release. As if Lordship's direct, we will release.
no,
Otherwise,
there's no
from
question
our
of
side,
direction. If there's a question of public interest,
public
involved,
interest is
then-
paramount here, Lordship.
Mr. Kumar, then it becomes difficult.
It's public interest is paramount.
My lord, there are even this assistant professor of
What-
GMCAs. They also, he is also working in SCI, GMC, Guwahati. We have made a specific statement in our petition.
What is the statement?
But this assistant professor 1
Hmm.
in GMCH Guwahati at page 60,
Hmm.
he is also working in SCI and GMC Guwahati.
GMCH,
Yes,
where is the assistant professor? Filled up, yes.
yes, filled up. He is also working, and your lordship will look into our pleading at page
What
70.
Mr. Kumar, what learned Advocate General says, highest footfall, if that is so. You see, providing medical facility to the citizens is of paramount interest. Even if your client is losing out some monetary benefits,
No,
the state can take care of that.
Not only
So
monetary.
let us serve here.
Not only monetary benefits. We
Yeah.
have given that we'll get more experience there. It's a better institute, specialized institute, my lord.
We have also tied up.
Your
with
lordship
TAPA.
will kindly
The
see.
state government has also tied up, and we are spreading 13 cancer institute in Assam, government of Assam and Tata Memorial Lordship. We have tied up.
My lord,
And
if
Tata
you-
is giving us money also for
my
that,
lord, if the
to some
state,
extent.
if some people come to
And
the
out of
state,
13,
and if the
7 are
state
functioning.
tries to hold this person in this fashion, my lord, where will the impetus to work, my lord? Where the zeal to work better in life will
That
remain?
argument will come in picture, Mr. Saikia. If you try to
Whether
act.
she
in
is
this-
not a bonded labor, Lordship.
No, I
Ours
have
is
not
also not
signed
a.
on with you.
It is not like that. We are compelling her, but she has come here and served, and she knows the service conditions.
That is right. There is no bond.
There is
And
no
how can
bond.
you refuse?
We can refuse because of the act, because
Only of the rule,
of the rule,
that rule.
309 rule.
But that rule, see, Mr. Saikia
Lordship,
has 4
every
parts.
other persons, we are not holding them back.
Hmm.
It's
Only in this
Only in case of
specialization.
doctors and these particular 4 areas.
Hmm.
It is not a general application, Lordship.
Yeah, that's right, that's right.
My lord, that
And
4
Lordship will
areas,
see the vacancy positions. Somehow we could manage to get the affiliation, this recognition again for another 5 years yesterday.
Mhm. Mhm. Have you not moved for filling up the other vacancies?
Lord, the problem is vacancy, when we apply, when we give the advertisement for 600 posts, 300 applications come.
So that's a
That is
difficulty.
a pan-India problem. Lord.
In Rajasthan,
Every-
every day we have to entertain writ petitions wherein resignation, voluntary resignation
Here also,
are
here
refused.
also see.
VRS is refused.
Jorhat Medical College, the assistant professor, he resigned. At least here, at least with the
See,
binding is because he
the
wants to go
need
to
of
another.
public at large
My lord, your
works
lordship will
against your
see
personal
this,
interest.
this is because of the wrong understanding of page 58. Page 58 talks about radiology, not radiation oncology, my lord. There's a whole lot of difference between
But the
radiology and.
statistics are there before us.
My lord,
Statistics is there before us. The
statistics,
chart is there.
statistics, your lordship will see
Hmm.
whether it is justification because 3+1, 4 assistant professors are working there. One professor who has been selected will go there. The
Saikya,
other 3 professors can't go.
We'll make an observation, we'll make it clear that your letter dated 11/3/22 talks of radiology. She has a specialization in oncology.
Radiation oncology.
No,
Lordship will kindly see.
where?
This
58.
page 58 is all right, Lordship. Her statement.
The NOC is being refused on this criterion.
Yes, Lordship. Because we want her service in this particular.
Where is the refusal of her prayer?
Refusal of prayer. Just a moment.
Her Lordship, page
Page
6,
45.
page 6 for a moment, Lordship. Paragraph 2.
Refusal order.
Page 45.
Where is the order? Let us read that.
Page 45.
There is no reason has been assigned.
We have.
Rule has been
26.
referred.
26 is
Rule is
public interest, greater public interest. And page paragraph 2, Lordship. Our MD is in radiotherapy, radiation oncology within bracket. This is her statement.
Radiotherapy and radiology.
Radiology within bracket, that is a specialized part of radiotherapy.
That's what we are saying. Radiology and these are very super specialty kind of thing.
Exactly,
So
Lordship.
even a slight difference
Makes
would
a
change
huge-
the
yes,
color of the entire thing. So
So
she
now-
says Department of Radiotherapy, Radiation Oncology, and your letter dated 11/3 says radiology, simplicity. So what we can do is maybe a resolution can come around. To consider a
Please
case,
to remand it back.
Yes.
Let us take a fresh call on this.
we'll keep it pending to take a decision again. First, they when council.
Otherwise, Lordship is not interfering with that particular, because he is not also praying.
No rule, we are not interested.
Lordship.
And
There
that's
is no
abandoned question. Otherwise, I would have been thrown out on that first day.
You are right. We will not interfere with the
Yes,
rule. No question.
That,
That- That power has to be given to the state.
yes,
Otherwise, it will create chaos.
yes.
Every doctor
I appreciate.
may be lured away by the private hospitals and the public will be left
Yes.
without any medical facility. Yes. Ms. Kamar, then council, Ms. Kamar submits that the letter dated 11/3/2022, which was issued pursuant to a meeting chaired by Honorable Chief Minister of Assam and attended by other senior officers, resolves that NOC would not be granted for various posts in the departments, number 1, FSM, number 2, anesthesiology, number 3, dermatology, and number 4, radiology. He urges that the specialization of the petitioner is in radiation oncology, and thus, the resolution referred to in the letter dated 11/3/2022 cannot come in the way of the petitioner to seek NOC because she has been appointed to another specialized cancer institute within the limits of the Guwahati city. That is, the name is
Bibora Cancer.
Dr. Bibora,
Bora Cancer Institute. He thus prays that the application of the petitioner for grant of NOC may be reconsidered in light of the above observations. We'll dispose it of then, Mr. Kumar.
yes, yes.
Mr. Advocate General, Mr. Saikia does not object to the such submission. Thus, requiring the respondents to objectively and without being prejudiced to the earlier communications, reconsider the prayer of the petitioner for grant of NOC in light of the above observations. within a period of 1 month from today, comma, the instant writ petition is disposed of. While doing so, comma, we make it clear that we are not inclined to interfere in the validity of Rule 26(2), which has been challenged in this writ petition.
Your lordship has disposed of it then.
Dispose of.
Suppose they reject that. again,
You will have another remedy,
Well,
single
your
bench.
Your lordship,
No, we are not interfering. We are not interfering in the rule. That is for sure.
My learned friend, Lord.
no, no, that would may send a wrong signal also.
no.
It is because of this.
Single
This
bench.
state is
Then,
not having
then
adequate numbers of-
validity of the order will have to be challenged.
Yes, madam.
That is all.
Because of this.
Needless to say that if any adverse order is passed, the petitioner shall be at liberty to challenge the same as per law.
We consider we'll like to relook it over it.
Maybe.
It is
That's true.
Give levels.
highly obliged.
Give it.
First over matter, item 16.
At a particular point of answer. Almost.
Because in the private hospital, they would be.
Yes. Yes, Mr. Chaudhary. What is your response?
Yes, Lordship, Lordship, I may just. Lordship, the foreigners who have been allowed, Lordship, those are, Lordship, the cases whose contracts have expired in the earlier, Lordship. Here, in this case, Lordship, he had signed a contract and which had expired, Lordship, in 2023, and as per the new policy, Lordship, after expiry, it has to be tendered.
Has to be done under the new policy only.
Yes, Lordship.
So contract agreement by itself stipulates that there will be no further extension renewal.
Lordship.
Have you got a copy of the contract agreement, sir? There is a term in the contract agreement itself that there will be no renewal.
Lordship, in my affidavit in opposition, Lordship, 339.
But then are your any vendors working now in this system?
So far as this is concerned, Lordship, since there is an order of status quo, we have not gone forward, but others have been tendered. And I have shown in my affidavit, Lordship, they are fetching far more revenue than the older one.
Oh, that's 3. You are referring to 325.
339.
That's the next at 339.
339. Yes.
And the tenure.
This contract was signed on December 2018. Yes.
Lordship,
So this was signed after the coming into force of the policy.
No, no, Milord, the LO was given on 17/1/17. Before
Sir,
the
please come to-
2017 policy
Please.
came on 27/2/17.
Please come to 339. 339.
It came, Milord, on 17/1/17.
I'll just,
Page 392.
Mr.
and-
Goswami, will you have a look at the agreement, please? The agreement is at page 339.
I'll just,
339 is also fine.
It was signed on 14th December 2018. And which is the condition?
That is paragraph 20, Lordship, or I have explained it.
Where is that condition you are referring to? It shall not be extended.
I'll come to that.
Page 225 is the policy, Milord, clause 22, your lordship has seen that.
Sir, please come to page 339, your contract.
Yes.
License agreement.
With reference to it, it's 339, 14,
Yes.
So that is signed in December 2018, after coming into force of the policy.
Your lordship, if I may take your lordship to paragraph 20, lordship will kindly come to page 333.
333 in your pleadings. We want you to read from the license.
In the affidavit, lordship.
Yes,
333,
yes.
paragraph 20.
Page given. Okay, let me see.
May I read it, lordship?
Hmm.
It is submitted.
So the allotment was made in 2017, but the formal agreement was entered into in the year 2013.
Lordship, lordship.
There will be no further extension renewal.
Yes,
So
lordship.
that is in the contract. What can be done, sir? So
No.
terms of the contract,
Your
you're bound by it, Article 3.
your lordship is referring to the contract, but the
Yes,
policy is below. Your lordship kindly see the tender notice was issued on 17/6/14. So they took about 4 years to.
what is the problem for you to apply afresh? What is,
The whole question is, below, these are small stalls,
yes,
static on the platform. On that, the policy decision taken by board itself, we have annexed all those letters. They are continuing to renew the
Mr. Chaudhary, you
licenses
say
because
that
of
those whose licenses came to an end earlier, they are being allowed to operate. Why?
their own
No,
documents.
no, lordship, here is a case, lordship, where my senior friend is referring to is, those were the licenses given under the
Old policy.
old policy,
Yes.
and there was a renewal clause there.
Hmm.
There was a renewal clause there, which has been done away in the new policy.
That is the.
In the new policy, lordship, in
New policy is.
2017, now whoever, now in here is a case, lordship, they
Page
had entered into an
225.
All
agreement.
right, what is the date of accepting his bid? Let us see.
Yes, that
Because
is what I'm
your
saying.
NIT was of 2014, Mr. Chaudhary. So how would the new policy apply to that process?
No, no, as per that, they were given a contract and the agreement had expired now. So after the expiry, it will be bound by the new policy, lordship.
No. He is arguing against his own.
Mr. Chaudhary, the
requirement.
very contract you are referring to,
Lordship.
that states that this is being granted pursuant to the bid of 2014.
Yes.
So for a bid of 2014, how would the,
That was granted when there was a clause for a period of 5 years.
the bid was accepted, formal agreement was entered into in the year 2018.
Yes, lordship.
So how would the new policy govern that tender?
That is what I am on, lordship. His contract was under the old policy, under which.
If that is so, then there is no dispute.
Under which he was given a contract period of 5 years. Contract period of 5 years.
Yes.
That 5 years has expired.
Hmm.
That 5 years has in the meantime expired. And therefore, now.
Now the new policy is in
new
place, so.
policy has come in. And the new policy says that whoever's contract was there prior was in commencement or.
Let us see the policy first. Then. All right. Where is the policy?
209 is the page below.
209?
Yes. The 2017 policy, 27/2/17, that starts at page 202.
Yes, sir.
Relevant clauses at page 225, clause 20.
Lordship will see page 225, applicability of the new policy. Below, lordship.
And that's what we are saying.
Yes,
Yes, Chaudhary.
Tenders-
This tender was finalized before coming into force of the policy. So 20 subclause 2 would entitle him to claim renewal.
Lordship will see 2002. Tenders that have been finalized and LOA
LOA issued.
issued.
Letter of
prior to the
allotment.
date of
So where is the letter of allotment? Do we have the letter of allotment, sir?
Yes, my lord.
Where is it?
Page is 392
392.
LOA. Three 392 and 394.
Yeah, all right. What is the date of the policy? Date of coming into force of the policy?
That is below 27 to 17.
7%. Ms. Chaudhary, 20 sub clause 2 would save him. Where's the escape from that conclusion?
And that's why the railway board has been issuing the circulars, and all other zones have complied with that except this landing zone.
Lordship, there
We have given all the
I have
railway board
beg to
orders.
differ because decisions, Lordship, if your Lordship will take up,
Forget about that part also.
yes, Lordship.
For the moment, come to your policy itself.
Yes, Lordship.
Policy condition 20.2 says where LOA has been issued before coming into force of the policy, the old guidelines will govern the contract between the parties. Under the old guidelines, there is a provision of extension. Is it not there?
As per the old guidelines, Lordship, there is a provision for giving a contract, and that contract was for 5 years.
Whether there is a provision of extension, you rule out extension on the basis of the new policy.
Yes, Lordship.
So, no, that is what the issues to be decided is that whether that clause of refusing to extend or denial of extension, which is introduced in the new policy, can be applied in a LOA which was issued before coming into force of the policy. Has there been any judicial challenge to this anywhere else in the country?
This matter, the original position was in that from Bombay. That is the judgment of reported in 2016, 8 SCC.
Yes.
Where it was, the contest was whether there is a renewal part.
In the old policy.
Old policy, that is with regard to 2005 policy. Therefore, the argument of Union of India on railway was that we have to get increased revenue. Therefore, we don't want to grant any renewal. And therefore, that was the matter which was decided. The Supreme Court held that these right accrues, they have really related it to a right of livelihood and the directive principle. And therefore, they said that everyone will have a right of renewal.
Can it be indefinite, sir? Can it be an indefinite right of renewal?
That is how
it can't be perpetual.
I quite see what your lordship is saying. In addition, thereafter, another branch will have supplemented it because that original judgment said that you will get one renewal. And subject to filing an affidavit that you may have not more than one stall. That has again been changed. And these matters are the Supreme Court later on said below by another bench that three things below that HUF, cooperative societies and partnership firms. That restriction of one thing will not apply. Therefore,
regarding the others, it will operate.
And the railway board has accepted that. And therefore, they have said that we are renewing all this. These are all part of the record. Below, we have annexed them. Therefore, the present position is the litigation is pending possibly in the Supreme Court also in the Delhi High Court with regard to these issues. But the position is that the renewal is allowed and status quo is maintained. And
status quo is operating in your case also?
Yes. No, status quo with regard to the continuance of the license. That is maintained. And that your lordship will see from their own documents, which you have annexed already. For example, for the minor stalls, 284. for example,
Hmm.
284, 285.
These are all cooperative. Achha, this is 284 is the private person.
This 284 is a minor catering, Nagpur. Rajendra Kumar Mangala, he is the catering stall thing. And they have issued the renewal, and 285, there is another from Sikandrabad. They are doing it. And a few others we filed that day.
What the learned single judge has said? Let us see.
Because the learned single judges judgment starts at page 29. His lordship was impressed by this argument, namely that 2010 contained a renewal clause, 2017 does not contain a renewal clause. Therefore, there will be no renewal. That's the sum and substance of the finding, which your lordships will get. At page 36, below para 18, on considering all the above facts, this court finds that the catering policy 2017 does not provide for renewal of license for catering vents and stalls. As such, the petitioner cannot have any legitimate right to have their catering vents stalls extended beyond 5 years. In terms of catering policy 2017, the passing of the interim order of status quo in so and so cannot, in the opinion of this court, mean that any final decision had been taken in the state case with regard to the subject matter in issue. As such, the interim order status quo passed therein doesn't help the cause of the petitioner. In view of the reasons stated above, the court doesn't find any merit in the writ petition. So the implication of the clause 20 in the new policy, with respect, will possibly he thought that since there is no clause,
that was not considered.
not that way considered.
You are still in possession of the. You are still in possession of the stall.
I am. They have put that clock in the interim orders which your lordships passed. We showed the photograph. They were operating after your lordship's order also. One day they come and put a lock. We have given the photographs. So all other zones will not, that's why will not, it has been.
This letter is slightly confusing for the reason that the renewal clause came into being only in the policy of 2010. The tender was issued under that policy.
Yes.
The LOA was issued in that policy.
Yes.
Contract was signed after coming into force of 2017.
Because the LOA was given back.
So only the formal signing of contract is in the after coming into force of the policy of 2017.
Absolutely.
So the litigation is going on.
Yes.
Let them operate.
Yes. That is how the matters are pending in Supreme Court and High Court also.
I would not.
No, you will not agree,
Yes,
but
Lordship,
your.
I cannot.
No, I can see, but your.
No, there is no question of conceding.
No,
we are not
concede.
asking you to concede.
No.
Who said so?
No.
There's no such
question of
suggestion.
concession. Railway board's own orders are there that you continue with the status quo.
So far as clause 22 is concerned, Lordship will kindly see page 33 for the purpose.
Yes.
33.
Yes.
Yes.
33, paragraph 12.
Yes.
Clause 22 of the catering policy 2017 provides that tenders that have been finalized and letter of approval issued prior to the date of notification of a catering policy 2017 shall be allowed to continue as per policy guidelines prevailing at that time. Zonal railways will cancel such tenders and return the earnest money to the tenderers in cases where LOA has not been issued before the issuance of the catering policy 2017.
Where is the judgment dated 13th March? which is referred to.
Lordship,
That is,
That-
I think, my lord's judgment on acceptance of the payment of the renewal. Your lordships have taken the view that that is virtually extension of.
Let us have the
Yes,
judgment, please.
your lordship's judgment is there. We have also paid, my lord, the license fee. Your lordship's judgment is that it is without case number writ appeal 54 of 2023.
47/23.
Yes.
Both were there.
Yes.
We relied upon an earlier order of the division bench.
Yes, another order of division bench, that is, my lord, your lordship has quoted that. And that really was on the footing that if you accept the money, then you virtually agree to the extension. So that is also another aspect of the matter, my lord.
If I remember correctly, Lordship, that in those cases, Lordship had passed similar orders a few.
Yes,
bunch
that's
of
right.
cases had come in and the-
So therein the direction was to pay the event fees at the enhanced rate.
And in fact, my lord, that 2010 policy also contains that clause, my lord, of revising the
Revising the rates.
rate at the rate of 10%. And in some cases in 14%. That is already there in the 10 policy. So that.
Whether this order has been challenged in Supreme Court, the writ appeal order.
Not to our knowledge.
So why there is a difference in the case of the appellants herein? Why they are not required to be treated in the same manner?
No, Lordship, the facts of those cases were slightly different. If I may take your
Let us
Lordship,
see.
the order, the quoted portion of
Yes.
the order, Lordship, at page 3, paragraph 8. Although Mr. So raises an objection to such submission of Mr. D. Majumdar, learned senior counsel for the appellants.
The ground was that the event fees license fees were continuously accepted by the railways. Have you not accepted in this case? That was considered to be a deemed renewal.
No. As soon as here is a case, as soon as his contract period was over.
Mr. Chaudhary, in no case 20.2 has been considered.
That's right.
What do you say about that?
No, Lordship.
Give us one judgment wherein effect of 20.2 has been considered. And the case wherein LOA was issued prior to coming into force of the policy. Simple argument.
I'll try to get that, Lordship. I'll try to get on 22. But here, Lordship, if your Lordship will read further.
Independent of this, irrespective of this observation,
This was on a different-
on merits, 20.2 is there. LOA was admittedly issued before coming into force of the policy.
Yes.
In that condition, whether you could have imposed that condition of non-renewal, was it permissible for you to do? Come at 2.
Lordship, can it be on Monday, Lordship? In the meantime, I'll get back to the authorities, Lordship.
All right, Monday.
But they have issued some circular on that basis, that's why you should,
Bring that circular
I will.
you have annexed some of them.
Monday.
Daily list for final disposal at admission stage. Item number 20 to 30.
Fair price shops. State. You're there?
The series of this matter, take up final hearing after vacation.
What do you say, sir?
As they are not comfortable, let them be comfortable and finally decide by your lordship.
And council, government council, Mr. Swanch submits. What is your good name, sir? R.K. Bora submits that he is not prepared the matters today, and thus hearing of the cases may be deferred beyond summer vacation.
May I pray for a specific date?
It will come up in August, sir. Then July, we have given too many dates. list for final disposal on 3rd August.
Third August, Masuk.
Yes, great.
For hearing, item 31.
May it please your lordship. My lord, the matter relates to that relaxation of. age.
Yes, we
My
were
lord,
trying to get your expert comments the other day.
No, my lord.
These notifications will not stand.
No, my lord. In fact, already this honorable court has set aside
What
this notification.
has been set
Yes,
aside,
yes.
then the automatic
Actually,
consequences,
Uh,
your extension, that will have to go.
no,
Then we have the
I
services
think
of
my-
advocate
no, my
general.
lord, what had happened?
Please
as
call
far
the
as-
advocate general.
Eh,
These cases.
My lord,
Would like
as
to-
far as the state of Assam is concerned, my lord, under 30 proviso to 309, there is already one.
But these
That is why, my
extensions,
lord,
these relaxation has been
Yes.
done by resorting to
yes,
totally illegal notifications.
yes. In fact, that has already been held, my lord.
Let's see,
If your
then what
lordship
will
will
be the
kindly have the
consequence?
judgment, my lord.
What will be the consequence on your
Now,
clients?
now, my lord, I think the consequence would be like this, if we go by the two judgments which I'll be relying, my lord, that 51 will continue to hold the field. Because, my lord, the moment it is set
Assuming-
aside, that is set aside from day one,
51, is it under 309? Again, the same question.
proviso to 309.
Yes, proviso. Is it
No, my
under
lord,
that?
proviso to 309 will continue until an act of the legislature comes in.
Now act is there. Act says no extension of age, no relaxation of age.
Act-
Act is excise, service rules. Service rules are there.
No,
You have been-
in the service rule, do they prescribe any age?
Yes, they have prescribed 38 years, fix. No relaxation permitted. So that
No,
is what
there
the
is,
question.
there is provision for relaxation, my lord, in
No.
that rule also.
No,
Rule
no.
27.
Let's see.
Yes, my lord. It is what this is. My lord will kindly come to that rule, so rule 27.
Yes, we are
Where government is satisfied that operation of any of these
rules.
Rules.
This is for operation of the rules,
Yes.
not for relaxation of age.
My
For
lord,
age, there is a specific provision. Let's see. Just hold on.
My lord, rule 8.
Yes, shall not be more than 38 years.
Hmm.
So where's the question of relaxation? By a notification, which is not issued under Article 309. Proviso
The
to
age of a candidate for recruitment to the cadre of his business shall not be
shall
less
not
than,
be
not more than.
more than. So there is no question of, this is not a relaxation of rule.
No, my lord, this prescription of minimum 18 and 13,
Yes,
it has been prescribed by the rule only under 309.
that's all right.
Ah.
Operation of a rule, supposing it is to be done, then it's to be done by the government. It can't be delegated. That has to be an order of the
No, my
governor.
lord, under the 1951 notification, the
Yes.
head of the department, Commissioner of Excise is the head of the department.
In any event,
My
the
lord,
primary
oh,
fundamental question,
my lord,
whether
my-
that
what I
notification.
was thinking, my lord,
Yes.
lordships will remand the matter to the single judge to take note of the subsequent development and take a fresh call.
Oh, the consequence is automatic, Mr. Chaudhary.
No, my
There are
lord,
ways of- Otherwise also, we are happy with the reasoning of the learned single judge. It's absolutely sound.
my lord,
What are the grounds? Just look at it.
no, my lord,
Mr. Advocate
this-
General, this is a issue wherein the state might face quite a huge backlash because the notification of age relaxation that is issued contrary to the provisions of the rules framed under Article 309. 309 doesn't permit relaxation of age. It does give the power to relax any rule, but specifically the age has been fixed, upper age 30 years. So perhaps you would like to take a look at it because the consequence, and we are told by Mr. Chaudhary
Yes.
that those rules have already been struck down.
That notification.
That notification.
Yeah.
Let's see.
In fact, there are two judgments, my lord.
Let's see, please.
Yes. First is, my lord, 2016 1 GLR 391.
Oh, 2016.
Yes, my lord. 1 GLR 391. And the other is, my lord, 2019 6 GLR 641.
Just let us see.
GLR asset. Equivalent GLT is also there.
Hmm.
1 second, 1 second.
Second.
Para 9.
ইটোৱে দিব লাগিছিল নেকি? এটা কোনটো পেৰাগ্ৰাফত কৈছিলে?
Even if we see the language of the rule, Leonard Single Judge has dealt with it. Para 10.
Yes.
In the interest of public interest or fair dealing, your relaxation orders do not reflect anything of the sort. That gives rise to so much of discretion. It can create havoc. An officer can do anything under the table. Let's see the age relaxation orders.
Order page 90, my lord.
Yes, read please. Whether it reflects at any place that it is being done in public interest.
With reference
fair
to
dealing.
letter I, you are informed that in exercise of power conferred upon me by notification dated so and so, relaxation of age is allowed up to the age of 45 years, subject to fulfillment of other requirement. So for the application to the post of excise constable and excise department for which requisition has been sent to the director.
So now read the note, your notification circular that
Yes,
says public interest, fair dealing. There's no reflection in these orders. They are absolutely arbitrary. There's no saving your client service, Mr. Chaudhary.
Yes, Lordship, I fully agree. Let me come in, Lordship, once and I'll get back to it.
For the present, we can say limiting it to this controversy, but leaving the state to examine the notification in light of 309 for its future course of action.
no,
They
the
can't-
notification stands quashed.
Even 51 can't be sustained, sir, on the same logic.
No, 51 is an under proviso to rule 309.
Are you sure?
Yes, yes,
Where
I'm
is it?
following that.
Where is it?
Yes. Come on.
Let us see.
Ujjwal Bhai judgment. It is there, my lord.
It must have been referred
It
to
has been upheld, Lordship.
Appel.
51.
Yes,
All right. 51.
it is under, my lord, in persons. Can I hold it?
Let's see. Yeah, that was the only
Yes.
question which was bothering us.
No, that's what I was saying, my lord. Yes,
Your Justice Ujjwal Bhai, Lordship,
Yeah, Ujjwal
for the
Bhai.
detailed judgment.
and that's the judgment of Ujjwal Bhai.
Yes, that
My lord,
reads on
in
the face of it.
pursuance of the provisions of Article
Mr.
309.
Chaudhary, that was the very question we posed
Yes, yes.
the other day, because this notification was
Not
not there
under,
on the record.
not under.
The age relaxation was done in 1980 and
And in
92.
In fact, on that ground only, my lord, that 80 notification was set aside.
That's precisely. So there's no saving these orders, Mr. Chaudhary. Absolutely. Harsh it may be, but on the
Already
face
12
of-
years, my lord. We are serving.
Alka Oja, 5 years as motor transport inspectors.
My lord, I was trying to rely on one judgment, my lord. 2006 10 SCC
Yes.
261.
What is Let's see.
2010 3 SCC 119.
What is the ratio?
Para 75.
Yes.
No.
Oh, judgment on age
I'm sorry, my
relaxation.
lord, I've given a wrong citation. But yes,
Age relaxation is there. The judgments, two judgments have been considered.
yes.
They
Alcauza is there, my lord.
Amilal Bhatt and FCI. They are the two judgments.
My lord, para 74 and 75.
Read please.
Yes. It is not disputed before us that relaxation of age is not only given to members of the scheduled caste, scheduled tribe and OBC, but also the dependent of freedom fighters. Such age relaxation is also given to ex-servicemen.
So these are specific categories.
No, my lord, para 75 regarding the view.
Read.
In our opinion, relaxation in age does not in any manner upset the level playing field. It is not possible to accept the submission of the learned counsel for the appellants that relaxation in age or concession and feud in any manner infringe Article 16(1) of the Constitution of India. These concessions are provisions pertaining to eligibility of a candidate to appear in an exam. At the time when the concessions are available, open competition has not commenced. It commences when the candidates who fulfill the eligibility conditions, namely qualification, age, primary written test, physical test are permitted to sit in the main written examination. With age relaxation and fee concession, the reserved candidates are merely brought within the zone of
Reserve
consideration.
candidates,
So, my lord,
reserve candidates.
yes,
So that
Yes.
is
so that they can
Peculiar-
participate in open count merit.
peculiar to the reserved category candidates, Mr. Chaudhary.
Well, at least one view has been taken that it only enlarges the field of competition, my lord.
For a particular category,
Well,
for a
I was
particular
only thinking,
classification.
after
They otherwise
12
also
years-
have that privilege.
my lord,
They otherwise also have many more privileges, which have been upheld by the Supreme Court. Reservation by itself.
no. This is a case pertaining
So
to
age
reservation.
relaxation, otherwise also, to scheduled caste category candidates, all service rules
Ah.
do provide age relaxation for entry into service.
But in another case, my lord, it was not a scheduled caste where, my lord, this view has been taken. That is 2006-10 SCC 261.
Let's see.
2006-10 SCC 261.
6. This is 10. 2006 volume 10.
10, my lord, 261.
Yes. अच्छा, पहले गलत दे दिया था आपने. Earlier you had given the wrong one. Yes.
The legal position obtaining in this behalf, para 32, my lord. The legal position obtaining in this behalf is not in dispute. A candidate does not have any legal right to be appointed. He, in terms of Article 16 of India, has only a right to be considered therefore. Consideration of the case of an individual candidate, although ordinarily is required to be made in terms of the extant rules, but strict adherence thereto would be necessary in case where the rules operate only to the disadvantage of the candidates concerned and not otherwise. By reason of the amended notification, no change in qualification has been directed to be made. Only the area of consideration has been increased. Those who were not eligible due to age
That
were
was
in
a general
2003.
relaxation. Mr. Chaudhary, that was a general relaxation.
The general relaxation.
That again is a different.
My lord, I was only thinking in view of the fact that, my lord, the
You see,
other,
the particular age relaxation orders, Mr. Chaudhary, do they not reflect of arbitrariness on the face of it?
my lord, is it possible, my lord, the authority will decide the case in terms of the, my lord, 51 rule, my lord, notification?
The
Lordship will-
learned single
Lordship
judge,
will, by
learned
maintaining
single
the-
judge has already undertaken that exercise. Please come to para 10. Para 10. Read, please. That discussion has already been made.
Countering the above
No,
argument of
para 10, condonation of age limit. Page
Para-
7, para 10.
106. I'm sorry. ma'am. Yes, condonation of age limit for recruitment is permissible only in the interest of fair dealing or in public interest, as specified in the government circular dated so and so. But condonation orders issued by the excise commissioner do not, however, suggest that power was invoked either in public interest or in the interest of fair dealing. However, since excise constables are to be deployed in field duties, it is also a matter of concern whether physical fitness was compromised for the overaged applicant. Undoubtedly, an aged person can also be fit, but the question is whether age relaxation was justified in public interest when thousands of young candidates were available in the free. That apart is the natural that fitness would gradually diminish as the age grows older. Therefore, it is difficult to comprehend how condonation of overage for the overaged applicant would be justified either in public interest or.
Now tell us, just give us one argument against this reasoning. There are very few occasions when Mr. K. Chaudhary is nonplussed. This is one of those. Yes, Mr. Saikit.
That's why the government did not file that bill. Apparently, it has been done.
Gross injustice. Those people who would have otherwise, younger people who would have got the job, what would be the consequence? That is why we feel that when we entertain the appeals, there has to be a very strict scrutiny while granting stay. This is the situation brought around. They have now worked for 5 years under a stay. It's a very, very strange situation.
My lord, only pays 44, my lord. Three candidates, they are otherwise also in, my lord. Pays 44, my lord.
44.
Yes. 726, 727, 754. Ganesh Das, Jyotirmoy Kakoti, Bobita Bormon. They were, my lord, they're
Within the age limit.
So
So
they
we will make a clarification that if any of these candidates were within the permissible age limits,
yes,
this order will not affect them.
fine.
Yes.
One thing only subsequently the upper age limit has been further extended.
Further extended. When? But that can't operate in this recruitment.
Retrospectively it cannot.
It can't operate.
Now it is 40, then 44.
Constables, no. This is for particular post is also relevant. Constable is a very important post.
In fact, my
Without
lord,
physical fitness.
Under the police act, it is 21 years.
21. All right.
It's a hard case.
It's a hard case, no doubt. We understand. Writ appeal dismissed with certain observations.
Next to call you, no?
Item number 32.
In this case, I have received a detailed consultation yesterday with all the information for last 20 years.
Okay.
Yesterday evening I received it. It was a letter dated.
Something has happened.
Lot of things. happened.
Okay. So we will just like to bring them on record.
Yes.
It should be in public domain.
Yes.
In
That
fact,
is what-
in fact, my lord, the onus was given on us. We are happy that my lord state has come up with the facts and figures.
That's
So my lord, we'll also try.
Ms. Chaudhary, if really development has taken place,
Yes.
it should come in public domain.
Yes.
Why not? Mr. Saikia submits that he has received complete information in terms of the order dated so and so and would be placing the same on record to an affidavit within next 3 weeks.
Lot.
Please start summer vacation.
Highly appreciated.
Thank you, sir.
আমি সিফালে যাব লাগিব তুমি ইফালে যোৱা মই ইফালে যাম
We are on the same side today.
Rare occasions.
And this is one case where all the parties are challenging the same learned single judge's order.
Oh,
my lord, while challenging the CA in Supreme Court, Kapil Sibal made the same remark. Once we are together.
Lord, earlier, lordships ordered that the
so we have not received the files as yet. Let us have the file. What is the controversy?
controversy is regarding that selection. By way of giving grace mark.
Grace marks.
Grace mark. And the learned single judge ultimately saying that grace mark is bad in law.
Is valid,
No, grace mark is illegal.
illegal.
Could not have given grace mark.
Hmm.
And but then court saying that 60% marks in both the papers.
Average, aggregate, yes, gross total marks. We had asked Mr. Mozumdar to provide us one statistics.
Yeah, figures we have received, Lord.
Can we have it?
Yes, Lord.
Lordships order is at 15-6.
Hmm.
So the recruitment process which is under challenge, in that case, Lordship,
5746
yes,
were
total. Four.
advertised and 4190 were selected and appointed. 1556 remained unfilled.
And 1266 grace mark, 2842 non.
With grace marks.
Not grace.
Where are those? Where is that figure?
Same figure, Lordship, out of total
Yes,
5,700.
in the bottom,
Yes, next line, 4190 were selected and subsequently appointed on 5/2/2021. This figure is not given. 1266, Lordship may note it down. 1266 grace mark candidates were there within that. And the remaining 2824 were appointed who did not get any grace mark.
Grace candidates are 1247, Mr. Saikia.
1266.
As per your charts.
1266. There are subsequently, there are two rounds of recruitments
Okay.
after this.
2 more recruitments have taken place.
Yes, Lordship.
Then those posts must have merged then.
Still today, the final figure, Lordship is pleased to come to the next page, last part. As on today, 5,781 posts are remaining vacant
Vacant, okay.
as on date.
Mhm. Mhm.
And in the
So-
meantime, we have recruited another 2 rounds, Lordship. There were some grace mark candidates.
Again,
Yes.
but then why
Because
this,
this grace mark was not given in the recruitment process.
then
In the TET examination.
TET, we know
So there
that
are
this is,
there's a huge gap between the 2 events.
because this grace mark is in the TET only.
In the TET,
That wherein the requirement under the rules is 60% in both papers.
yes, Lord.
And the candidates who have come in before the court in writ petitions, they say that we have aggregate of 60%.
Here there are 4 different types of prayers.
In aggregate. You too. The state
Rule
took that decision.
says 60%.
60%
And in our advertisement, we said, in the advertisement, we said 60 in each paper.
in each paper.
And
Or
finally, we found that there are very few candidates who have passed
in 60 with 60 in each paper.
in each. So we decided that up to 5 marks in one paper, we'll give this.
Okay.
Just to give a proper competition for the post. Otherwise, those who have qualified in the TET, they will only get the post.
Mhm. Okay.
And
But
then
then-
there is a clause of relaxation also under the act. And this particular
We understand.
TET
No,
is
no,
not
no.
under the NCT.
You
Because
tell us.
NCT is for the elementary education. This is for secondary education,
Secondary,
where there is no national yardstick and none of the other states are having TET for secondary education.
Mhm.
We have introduced to our act
Mhm.
and there is a provision of relaxations, Rule 33. And government has exercised that power.
All right, let's see.
And nobody has initially challenged the granting of grace mark.
The granting of grace marks was before the
Much
recruitment
before,
examination.
the results were declared on 4th of March,
Okay.
2020.
Mhm.
Advertisement was issued in September 11, 2020.
Okay,
There is a huge gap of 7-8 months.
but this indication that you will be considering people with grace marks, that was given only in the advertisement, recruitment.
It is
notification.
like this, Lordship, I have passed graduation, BA.
Mm.
In my Pune University, there is a provision within the university rules that I can get 5 marks grace
Ah,
mark or
that's
10.
all right.
In a lot of universities, that is the norm.
That's-
Subsequently, in a recruitment process, a graduate is required. So he submitted his certificate as a graduate to come into the consideration of eligibility.
Mm.
So that is my situation,
The broader question, because why we asked you for those figures is,
Lordship.
the broader perspective is that if in this very recruitment process,
Lordship.
you have got vacancies and you have got qualified TET teachers, why didn't you appoint them?
There are shortages, Lordship. That is why some posts still remain vacant.
That's what we are asking you. Why can't you offer them the posts?
They are not qualified. Because
Qualified in?
no, only that is not the criteria.
They are not qualified in the recruitment process.
The thing is like this. One is, Lordship, when we do the tabulation, we take the marks from TET examination marks, we take the examination marks from the higher secondary and the graduation and the BEd, the other parts.
So the in
Tabulation
totality,
of various, there is no written test here.
yes. That's only a tabulation.
That is a tabulation.
Compilation of marks and then
Exactly,
preparation
Lordship.
of
And
the
there is no
merit
written
based.
test.
Right.
And marks of various categories of examinations are
Okay.
taken into
So in
not
that they
only
did
that.
not qualify.
Then perhaps not. Individually, we have to look into it.
Ms. Chaudhary? Yes, yes. Hmm. Hmm. Yes. So, yes. Okay, so you are those candidates who did not even qualify despite grant of 5 grace marks. That's what. So you were not given grace marks because in one paper you had less than 55. That is, so you were left out on that count.
So they need more grace marks. That is one category.
Right. With this prayer.
That is where everybody
That
is
was
offended by the judge.
Allowed. Okay. Very well, let's see the scheme of the rules then.
Scheme of.
Yes, let's see the scheme of the rules.
Oh, lady.
Five petitioners, they are without guest. Without guest 60% in both.
In,
Both the papers.
but in one of the papers, without grace, 60%.
60%.
But then why your clients were left out? What is the reason?
Now, as has been expressed by my learning friend, it appears probably that we could not qualify in the sense the evaluation total aggregate marks.
Aggregate marks.
That may be because of those people who have been brought in by giving grace mark, or those who have been brought in by treating their marks in aggregate.
Yeah,
Otherwise,
but
they are qualified.
Mr. Mantha, the issue is that there are seats lying vacant. Is there a cutoff
No,
in the ultimate tabulation?
no.
Is there a cutoff concept? If that is not so, those who were qualified in TET as such.
Lordship, it can be like this, Lordship. In certain situations, some reserved categories, the vacancies position, we are not indicating category wise, like SC, ST, we are various categories, Lordship, and districts also.
Is it
So
this-
vacancy is there.
Mr. Saikat,
He
this
must have got-
category of candidates, those who are already having the requisite average of 60% in TET, or rather no, in both papers, 60%.
Lordship.
And if you are having vacancies, why they were excluded?
Vacancies because suppose they have applied for general category vacancies and general category vacancies already filled up. Then they will definitely not come into a zone of appointment.
Okay.
That
So no-
may have been done by taking into other category candidates.
Of course, you are aggrieved against those people who have been awarded grace marks and then they've been brought in. You say that they have eaten away your seats.
Because they may not have scored good marks in the graduation or the higher secondary.
All right, let's see then the scheme of rules. Yes.
And they see, my lord, this will.
Rules of 2000,
2018 rule 10 is.
2018 rules, my lord.
Yes.
50 of the.
50.
Yes, I.
It was 10 minutes. Qualification.
Before that, worship we see page 30. That is rule 10, academic and professional qualification.
Rule 10.
Rule 10. Page 30, my lord. This book. The academic and professional qualification for direct recruitment shall be as in Schedule 3. In addition to such academic and professional qualifications mentioned in Schedule 3, for direct recruitment to the post, candidates shall have to appear and pass in the research eligibility test step in the concerned cadre
Yes.
conducted by the government, scoring a minimum of 60% marks. In case of unreserved category, and minimum of 55% marks in case of scheduled caste, scheduled tribes, other backward classes and person. Posing for a number. The rule doesn't say 60% marks in aggregate. It says.
That is Mr. Mantha, subject matter of interpretation.
Yes,
Whether it can be treated to be an aggregate or whether it has to be an individual.
yes, that leaves a scope.
That's
Now,
scope.
Malala,
That's-
that has been clarified by the authority themselves, that no, it should be in each paper. In each paper, because there is two parts, one is the language part, the other one is the pedagogy and all. So therefore, in both parts, they want that one must come out successful.
Okay.
60%
Yes.
To be eligible,
Where is that clarification?
provided, sorry,
Where is that clarification provided?
in the advertisement itself. Rules, it is not there, in the advertisement, they clarify.
Okay, we'll see that.
Page
Very well.
2, I placed it last time, Lordship. It's page 8.
Okay.
Provided further, any experienced officer who has appeared but could not secure the minimum of qualifying 60% marks, it is that shall be awarded at least 60 marks in respect of their experience if he or she has already
Complete 15 years.
That-
That is on account of experience.
on experience, that been given some concession. Then three, the teachers engaged on contractual basis in a provincial higher secondary high school under the scheme, strengthening secondary education shall be given preference for recruitment to the post of graduate teachers by awarding 50 marks, bonus marks for their service in contractual officer. That we can also stick. Four also they think, they say, that teachers working continuously for fixed basis, other than contractual teachers. A provincial and higher secondary school.
Right.
It shall also be given preference. That we can.
Okay,
So
yes.
now kindly come to.
Which is the rule which gives power of relaxation?
Relaxation in my application 33, rule 33. Before that, Lord may also read 30, mode of employment. The members of the service shall be employed by the appointing authority following the principle prescribed in these rules and in the best interest of public service. That is the rule, mode of employment. The teachers appointed in the charter shall be liable to teach in any classes, either in higher classes or in any lower class, on the basis of his her qualification and experience. They clarified the post of graduate teachers in the secondary school or higher secondary school shall be required to teach in lower classes, that is 9 and 10. And the graduate teachers having postgraduate degree who have been initially appointed for teaching in class 9 and 10 shall be required to teach in higher classes, that is class 11 and 12, the relation subject which needs to have degree. Then kindly come to relaxation. 33. Where the government is satisfied that operation of any of the to any particular case, it may dispense with or relax the requirement of their rule to such extent and subject to such conditions as it may consider necessary, dealing with the case in a just and equitable manner, provided that case of any person does not be dealt with in manner just be then provided as a full sufficient. This relaxation is not applicable to a person before he is a member of the service.
If he is a,
If he is a member of the service already,
then only,
that case relaxation may come in certain cases. This is a subjective satisfaction must be thrown in. Before a person becomes a member of the service, relaxation cannot apply to him. All conditions mentioned in the repeat.
this power is given, on a case-to-case basis.
Case to case basis, not in general. That took before entering into the service. No, it's not possible. That is not affected here. Then, what you will see, schedule 2 and schedule 3, they mentioned it.
Yes.
Here criteria for selection of postgraduate and 2 criteria for selection of graduate teacher is 50 miller. Schedule and that 2 plus 2 and then marks on percentage of marks in BA, BCom, BSc examination in case of matter or honor. The marks obtained in matter on 100 marks on percentage of marks in high school final, 100 marks in percentage of PPPO, 100 marks on percentage of marks in PT examination, or 60 marks for 15 years of experience as in undergraduate, junior officer in retail and higher secondary school, having requisite academic and professional qualification. Any experience with who has appeared but security minimum qualified marks.
So the TET composes 25% of the evaluation criteria. Okay. The TET would give 25% of the evaluation criteria.
This is the 100% mark.
There are 4 components.
Yeah.
One of them is TET. So there are 4 components, each of 100 marks. So TET would comprise 25% of the evaluation criteria.
That is 25%
Of the,
evaluation criteria. This is one of the four. criteria.
one of the four.
Yes, one of the four. criteria. Then explanation of for the purpose of calculation of marks under the category mentioned in clause 1. Yeah, above, it may clarify that if a candidate secure, for example, 60% marks in a particular examination, he secures 60 marks out of 100 marks allocated to the. This is how, whatever mark is they have secured out of 100, entire mark will come for
Experience.
So we are also.
Contractual employee.
Then Schedule 3 will can come to 54. Minimum qualification, educational and professional qualification for direct recruitment in the post of postgraduate is a graduation with at least 50% marks from recognized university and bachelor of education from National Council for Teachers Education.
Is this relevant for this compromise?
Graduate is a graduate, postgraduate from recognized university with at least 50% marks in either graduation or post-graduation or equivalent and bachelor of education from National Council of Teachers Education. Recognized institutions are obtained from off-campus distance education institutions as well. So one who thinking this qualification, he can only apply. He have applied. And we also qualified in the test without. Now, they have left out from being appointed and got in ourselves by giving.
By giving grace marks.
And probably to my understanding, as was submitted in the last occasion by Mr. Muzumdar, that those who have secured 60% in aggregate, they have not yet been appointed. Maybe that was the, those who have immediately directed that you consider now, evaluate it afresh. Make out a fresh list.
Right.
Of successful candidates taking the aggregate 60%. That exercise was directed to be done. On that basis, probably government has not. But grace mark holders have been.
Grace marks.
When the grace mark holders, the point are that grace mark holders may have secured some higher marks in some subjects.
Right.
So we are eliminated by them. At any rate, grace mark holders do not have any right. Grace mark holders cannot be allowed to participate in it. Because they are not that qualified. And if the argument is real, that well, we have allowed them to participate, but the grace mark has been minus. We have not considered that grace mark, that is 5 marks in total.
While evaluating it in accordance with the
tabulation.
criteria tabulation. Yes.
Well, this is also in Bida Scroll Service fallacious. You have found them entitled and allowed them to enter. Then you do not consider this. It doesn't make any sense. When their entry itself was not permissible. Therefore, at any day, well, they could not have been considered at all. It is against the law and it has set a very bad precedent. It has really made all such competitive examinations meaningless. Yet one thing, you may say that yes, successful candidates number has come down, then the vacancies lying. Then they could have held that again. At least once the rules say they want number of times, twice they can hold. People who will come out successful, only they will go for. Because one who aspires to be a teacher, you will have to strive for and you will have to adopt himself and make himself efficient enough.
Efficient.
Because here kindly see, well, in the schedule itself, they have said in the advertisement, what is the requirement?
That's it.
Page 82. My Apple memo. Apple memo 222, madam. That advertisement dated 13/11/2019, which is the foundation of that examination.
Yes.
Page 79, madam.
Page 79
Of Appeal 222.
of
222. Appeal number 222.
222. Mr. Saikia, wouldn't this exercise have been done in this manner? First, you take those who are TET qualified as per the TET regulations. First, you take their cases, and then if there are any seats left out, then you give relaxation. Why the excise? First you take in the relaxation, persons with relaxation, put them at level playing field, and then open the field. How that can be done? This is causing disadvantage to people who are otherwise directly qualified. That discrimination, why should it allow to prevail? This is possible. Yes, you can take the decision if you have vacancies available. Then all right, you say, now we come out with a separate category wherein we provide relaxation to people who are otherwise not yet qualified, so that the vacancies can be filled in. That can be one of the criterion. But at the inception, putting in people who are at a lesser pedestal, lower pedestal, than those people who are directly qualified.
The government, from that perspective, Lordship, had taken a decision that those who are getting 5 marks grace, those 5 marks are not counted.
That's not the issue. The issue is that they were otherwise, in the prevailing facts, not qualified to appear in the examination, in pursuance of the recruitment notification, to apply for that. They could not have applied, but for your relaxation. So relaxation rule, that
We, Lordship, like this, in February, we have conducted the test. On March, we have announced the results. Thereafter, 2 marks were additionally given. That
is a revision of result.
Wrong.
Revision of results is not very.
So the answer was that this whole result was out regarding the TET was done in the month of March. After 7-8 months, the recruitment advertisement was issued. Nobody had challenged that at any point of time. Number one.
Challenge issue is that for the first time, you would have allowed these people with grace marks to participate in your advertisement.
Because we have the authority, we have the power under the rule to relax. It is not that one individual we are relaxing. It's a general relaxation we have.
Relaxation of the provision you read that states case to case basis.
Here the case is, single case. That in one particular TET examination, we are looking for at least, the vacancy position was around 6,000. So we want at least 20,000, so that 3:1.
That's what we are saying.
But it was almost same without grace
that's
mark.
what we are saying, that this exercise could have been done in a more fairer manner if you had kept them in a separate category, that they are directly qualified, so they are in a separate category. Always, if you consider relaxation, giving relaxation, they will come on the second lower pedestal. You can't place them on the same pedestal as the
Lordship. Absolutely. Had it been at the initial stage, Lordship, suppose they had challenged it at the very beginning, we could have gone through that exercise. But that exercise was done in 2020.
So this relaxation in that qualification, when precisely that was made public, brought in public domain?
It was 4/3/2020.
Let us see that.
Yes.
Let us see that result, wherein you have given that relaxation. Decision.
Yes.
Of relaxation.
Lordship will kindly take my affidavit.
Yes. In which rate?
Yes.
In which
Writ appeal, the state's appeal.
186. State's appeal,
186, Lordship.
Yes, all right. Let's see that.
Page 475.
475.
Paragraph 9.
Just. No. Yes.
That it is stated during the evaluation of the result, it was noticed that only 6 have Lordship got it.
No, we got. Para 9.
It was noticed that only 6,879 candidates had qualified the TET examination. Therefore, a conscious process was initiated regarding the poor performance of all the candidates, and several aspects were examined. After due deliberation, a decision was taken to award. There were 4 options available from the record. One option was adopted.
What is the date of this decision?
Yes, that decision was prior to 4/3/2020. I have the records also.
Let's see the date of the decision.
All candidates, several aspects were examined. After due deliberation, a decision was taken to award the maximum grace mark of 5 marks in either paper 1 or paper 2 candidates who had qualified either of the 2 parts but failed in one. On award of such grace mark, it was seen that the number of candidates who would qualify stood at 11,322, and accordingly the results were declared. The results were declared on 4/3/2020. That Lordship will see the minutes at Annexure 1.
Annexure. Page number
477. No, this is a subsequent minutes. if I am allowed to go a little bit further, Lordship, that date is in paragraph 6, page 474. The last line of paragraph 6. The results were declared on 4/3/2020, 4th of March.
This included the exercise of giving grace marks, 4/3/20.
Everything. That is where the learned single judge made a mistake, Lordship.
What?
According to the learned single judge, in May, we issued the advertisement for those who are having some doubt regarding the 2 key question answer wrongs. The learned single judge thought that in May, we have announced that.
Relaxation.
Relaxation. In fact, before the result, the government took a conscious decision. It is on record.
Okay.
And nobody doubted this, Lordship. And those who could know that I have 2 wrong answers. So those were given the
That is a
opportunity.
revision of result on basis of
After
objections
the
against.
results were declared. After declaration of the results on raising the challenge of the key question and on receipt of clarification from the resource university, the TET empowered committee decided to award the marks for the wrong answer keys to those candidates who had not secured marks on that particular
All right.
question. After this exercise, 12,032 candidates were declared qualified, out of which 7,417 candidates were qualified on merit and 4,615 candidates qualified on grace mark. The grant of grace mark was the outcome of conscious decision on the part of the government to tide over the difficulty which arose due to meager number of candidates who cleared TET qualification marks. Such decision is permissible in view of the provisions of relaxation under Rule 33 of the Assam Secondary Education Service Rule 2018. This decision was also never challenged.
There's one catch in this. Are the TET examinations conducted under the rules of 2018?
Yes. Yes.
Read, please.
Rule 10A.
Rule 10A.
And according to the learned single judge, we have conducted the TET under this and under NCT guidelines of 2010.
Yes.
That guideline is not applicable for secondary education. That is exclusively applicable for elementary education, which comes under the RTE Act of 2010.
All right.
RTE Act is not applicable for secondary education.
Let's see that.
May I read it, Lordship?
Yes, please, sure.
Rule 10, academic and professional qualification. The academic and professional qualification for direct recruitment shall be as in Schedule 3. In addition to such academic and professional qualification mentioned in Schedule 3, for direct recruitment to the post, the candidate shall have to appear and pass the TET in the concerned cadre conducted by the government, scoring a minimum of 60% in case of unreserved category candidates and minimum of 55% marks in case of scheduled caste.
So this is all right. This is a qualification for being appointed as a teacher.
Apart from that,
are there any guidelines governing these tests? TET examination.
TET examination that in the advertisement we have given the details.
Do you feel that the examinations, the entire scheme of examination
Yes,
can be
it is
without a guideline?
Guideline is in the advertisement because the NCT guidelines is not applicable here and there is no requirement of having TET in secondary education. The other day I made a submission before this honorable court that we are going for written test and we are abolishing TET for secondary.
Yes.
So in elementary we cannot do it because there's a central legislation. The guideline has been issued under section 23 of the RTE Act. So that has a statutory backing. But here on our own in 309 rules, state wanted to upgrade the standard of the teachers, therefore introduced TET. And now we are seeing that it is causing some negative effects because the candidates are not coming out successfully. Although they are scoring good marks in their graduation or other qualification marks, which is there. And apart from that, Lordship, would kindly come to page 51 for a moment of the rules. It is not that only 400 marks, there are some additional marks also. So criteria for selection of graduate teachers, 100 marks for BA, etc. That is graduation, 100 marks for HS finals, 100 marks for BT, BA, and 100 marks percentage for TET.
This is for general candidates. Then there are some specific categories.
Yes, 2 categories, Lordship, Roman 4. 50 marks at 25% for 1 year of teaching experience of contractual teachers and another 25 for 2 years. That is another 50 marks.
So that these are marks for experience.
Then for 10 marks for NCC, then 10 marks for sports and 10 marks for arts and culture. So there are a lot of other components. And on top of that, we are not taking into account in tabulation grace marks. Suppose one person has got 2 marks.
Their
that marks is not.
Their objection is that you are allowing candidates who are otherwise not qualified. That is what their objection is. All right, let's see.
No,
Let's proceed. now.
because that decision of granting GACE was never challenged by them. Number one. The marks which was obtained.
Let's see the result. Where is the result of TET? Wherein there is a decision to grant grace. Where is that order
Increases.
or minutes of the meeting?
Yes, yes.
Are they on record?
It is in the file, Lordship. It is not in the public domain. In our affidavit, we have stated, if Lordship wants to look into the records, we have the records with us.
This question is coming, query is coming because you said that this decision was never challenged.
It was
So
never,
is it a part of the record?
because the results were already announced.
Only in the results it was indicated.
It was.
Let's see the result. Where is the result? Result at page.
Just 1 second, Lord.
There has to be some reflection of that decision on records, no?
Certificate, account certificate.
Mr. Manta, where is the TET result? Is it there anywhere in the record? Mr. Botakur. So question here is, Mr. Manta, that whatever decision was taken, it has to reflect in some kind of communication.
That question is,
So where is that?
my lord, that was only revealed when this petitions were filed.
So where is that decision, sir?
They have not placed it. They have just.
So you are required to get it summoned and then challenge it.
My lord, that challenge is implicit here.
We understand, but we want to see what was the reasoning behind it.
That of course, Lordship may see.
All right, then we'll ask them to place it on record then.
They have not placed it, but kindly see.
Do you have that file with you?
All these these results were uploaded in all the these death certificates and the mark sheets. There is a direct indication. 58 plus 2 grace, 59 plus
Mr.
1 grace.
Mr.
These are all
Saikia,
in public domain.
we understand, but then there has to be some decision behind this action.
Decision is there, Lord.
Where is that decision?
I can. It was never, because it was in the learned single judge.
See, now you are in appeal. You are in appeal. And
That
we
is why
want
the
to
records
know,
are ready.
and we want to know
Then
that what was the,
absolutely, Lordship. Then I'd like to file a short affidavit indicating the this.
can we have a look at it? please?
Yes.
Just a cursory look.
Yes, that is.
Just one thing, by the time the record comes, according to our information, my lord, my senior colleague Mohan's client, most of them have got job. If I'm not mistaken.
They might not have paid him the fees.
90%, 90%.
They have not come down to pay him the fees. In which recruitment? In this one only?
Yes, they said very first, no, but there are 3 recruitments. The one which we are concerned now, and subsequent to that. there-
So then the issue of seniority comes in.
Yes. Subsequent requirements are there. Our information is 90 to 95% of the 61 appellants have got the.
Maybe.
In
Let's
subsequent-
just have a look at the decision, the reasoning behind the decision. So if the reasoning is sound, that would be the concluding part.
If I may meanwhile. We put to challenge that grace marks could not have been awarded at all.
Right.
That is my concern.
We understand,
Yes.
but where is that, sir? Where is the decision? We will have to gather it from the decision, whether the decision was as per law or not.
Lordship will definitely appreciate that. Other certain scheme, they are holding certain examinations. There must be indication that there may be relaxation also. It's also there.
We quite understand, sir. Now they are saying that 33 says case. They are treating the situation to be a case.
That is again.
That's the situation, their anticipation that they would not get the enough number of teachers.
Well, that anticipation is unfounded. People at that time, they cannot, could not have.
Well, that will be reflected from their
And
discussions.
again, my lord, again, when they have, first time, had it been the case, first time they would have taken a decision made it public because that would have prejudiced many. Because when there is no relaxation clause, people were under the impression, it's only going by 60% aggregate, even will not do. Every paper one must come out with 60.
Four options were available to the government.
Just.
There is a gap of 6 months. Schedule advertisement. Okay. And who knows it up to 9?
Option 3 was adopted.
So the maximum number of candidates became available by that. To bring this fact on record through lordship. After addressing the court for some time, then Advocate General Mr. Saikia submits that it would be advisable to bring on record the details of the decision whereby, it was details of the discussion whereby, it was decided to award grace marks to the candidates in the who procured the TET qualification, who appeared in the TET examination so and so. Wisdom is granted 3 weeks time to bring these facts on record. Re-notify on 19th July.
Deeply obliged.